Labas rytas visiems. Labas rytas. Tai sveiki visi atvykę į pirmąjį projekto MAPE Successions paveldėjimo reglamento taikymo stebėjimą.
Good morning, ladies and gentlemen. Welcome to the first project, MAPE Successions, Monitoring and Evaluation of the Application of the Succession Regulation. It's nice to see you, everyone here attending and watching the seminar in a remote way. I invite you to welcome the President of the Lithuanian Chamber of Notaries, Marius Stračkaitis, who will give the keynote address. Good morning. I'm delighted to welcome you today to the seminar on the monitoring and evaluation of the application of the succession regulation. Onto the project. The relevance of the topic is illustrated by the fact that today, not only representatives of Lithuania are here, but also those of Latvia, Estonia, Poland, Germany, Slovenia, and other countries. Succession law is one of the areas that Lithuanian notaries face very often. Before the entry into force of the succession regulation, in succession cases, notaries normally used the Lithuanian law, namely the rules of substantive and private law. With the entry into force of the succession regulation on August 17, 2015, another relevant piece of legislation emerged. It should be noted that the succession regulation not only provided answers, but also has raised a number of questions. Lithuanian courts have already referred twice to the Court of Justice of the European Union for a preliminary ruling on the interpretation of the provisions of the regulation. I'm glad that not only researchers, but also European notaries who provided relevant data and insights were involved in the analysis of the application of the succession regulation. Today, researchers will present the findings of the research carried out for the first time, and notaries will share the practice of applying the regulation in a range of countries. I believe that the discussion today will be useful and will contribute to the preparation of proposals for the improvement of the succession regulation. Have an excellent day and a productive seminar. And now I give the floor to the mastermind of this project, a representative of CNUE, EU project manager Gianmarco Garamone, who will speak on the context of cooperation with CNUE.
Dear members of the Lithuanian Chamber of Notaries, professors and lecturers, dear participants, ladies and gentlemen. It is a pleasure and a great honor for me to represent the Council of the Notariate of the European Union today, and it is a privilege to be surrounded of bright professors and practitioners from many different countries in the beautiful city of Vilnius. First of all, I would like to thank President Marius Stračkaitis and all the members of the Lithuanian Chamber of Notaries for hosting us today and for organizing this seminar on the succession regulation. We've had a very smooth collaboration, and it's always very easy to work with all of you. The fruitful cooperation between the Lithuanian Chamber of Notaries and the CNUE has been lasting for several years now. And we've been working together in projects concerning training, legal mutual assistance, and analysis of EU legislation in this context. Events like today's seminar are crucial to bring notaries from different countries together and exchange good practices and experiences. The most recent event of this kind that was organized here in Lithuania was a seminar on data protection on the 22nd of February of this year in the framework of another CNUE European funded project. At that time, Russia was threatening to do what only a few days later became the brutal aggression on Ukraine that we all know and firmly condemn. And within this context, at the initiative of the Lithuanian and also the other Baltic notariates, the CNUE decided unanimously to, decided unanimously to accept the Chamber of Notaries of Ukraine as observing member on the 1st of March of 2022. This is just an example of the efforts of the Lithuanian Notariate in supporting the Ukrainian people in these difficult times, and as well of its commitment in the CNUE activities. In fact, since that day, several other actions have been carried out by the CNUE in order to bring support to Ukrainian people in different ways. Please allow me to say now a few words about the context in which this seminar is organized. I will not go into too much detail because I am sure that other speakers after me will. Monitoring and evaluating the succession regulation is a EU legislation analysis project coordinated by the CNUE and financed with the support of the European Commission. The project started in November 2020 and will finish in March 2023. The objective of this project is to carry out an in-depth analysis of the regulation number 650 of 2012 and to provide the European Commission with suggestions for the improvement of this piece of legislation, which will be reassessed in 2025. The large-scale evaluation, led by an excellent team of professors, was carried out with the collaboration of the European Network of Registers of Wills Association, the German, Hungarian, Lithuanian, and Maltese notariates as partners, and featured the participation of more than 2,100 notaries from all the 22 CNUE countries. These notaries shared their experiences and their point of view on the application of the regulation. The work of the Scientific and Steering Committee of the project was chaired and coordinated by Marianne Sevindik, President of the Successions Working Group of the CNUE, and notary in Rouen, France. This is not the only project in which the CNUE members work together in order to provide different services for notaries. In fact, we have the project EU Law for Notaries, Notaries for EU Law, which is a training program aiming at a better application of the EU law in the field of data protection, company law, and family law. On the one hand, by organizing practice-oriented face-to-face seminars like this one, and on the other hand, by setting up a new e-learning platform for all notaries of Europe. This platform will provide free e-learning modules available for consultation in an asynchronous and self-paced manner. Another important project of the CNUE is the European Notarial Network, which is a large online multilingual source of information, providing also mutual legal assistance tools for notaries, helping them in their cross-border cases. If you have not done it yet, you should have in your folders a small leaflet giving you all the instructions in order to register on the ENN platform. It is free of charge, and you can find there a whole set of tools and information that could really help practitioners to face their cross-border cases. Finally, we have the Jubilee project, Jubilee standing for Justice Without Litigation, coordinated by the Austrian Chamber of Notaries with the CNUE as partner, and aiming at analyzing the non-contentious judicial proceedings, such as, for example, the succession proceeding, that are frequently carried out by notaries. The analysis has been carried out in mainly Central European countries, such as Austria, Croatia, the Czech Republic, Slovakia, and Slovenia. The project is finishing in November 2022, and its final conference will be held in Brussels on the 9th of November. Of course, you are all invited to join the conference, and more detail will follow on the CNUE and on the Austrian Chamber of Notaries websites. Thank you all for your attention, and I wish you a fruitful seminar. Thank you.
Ačiū, Gianmarco.
Thank you, Gianmarco. The seminar is attended today by a number of notaries from a number of EU member states. From Romania, we have representatives online, and we will share during the seminar the experience of different countries of European Union in the application of the succession regulation and present the studies and preliminary findings carried out during the project. Some practical information. The seminar takes place both physically and remotely on Zoom platform. The seminar is being recorded, interpreted into English, Lithuanian, and French, and live broadcast of the event takes place on the account of the Lithuanian Chamber of Notaries on YouTube channel. All participants who are physically attending the seminar today have received evaluation forms from the seminar together with the program. Please fill them in and leave them before you leave the seminar. The seminar will be moderated by my colleague, Sima Sakalauskaite, and I, legal advisor at the Lithuanian Chamber of Notaries, Egle Čaplinskienė. I invite you to start the report session. The first presentation from the Association of European Tester Registers, European Network of Registers of Wills, it will make it easier to find a will in another European country. President of the association, Octavian Rogoianu, will present the register and will talk more about it.
Moment. Good, that's me. So, I'm going to tell you a little bit about a very useful tool for the notaries. No? Doesn't work? Yes. That's us. Okay, thank you. So, as I said, I'm going to tell you a little bit about our association today. It's called the Association of the European Network of Registers of Wills, ENRA, or ARERT, in the French spelling. We are a very good example of fruitful collaboration of the European notaries. And first of all, I will present you a little bit of the history. In January 2001, the notaries of Europe decided to create a European network of registers of wills. And it started actually 1 year later with the interconnection of the French and the Belgian registers, of course, with the support of the notaries of Europe, called at that time CNUE. We started officially in June 2002, but it was, first of all, it was interconnecting between the Belgian and French and the Slovenian colleagues. And it was mainly done by the notary because the notaries do play a key role in the settlement of the successions in each country. And so in July 8, 2005, we opened for the managers of registers of wills, and we should think that it was a very good idea. The activities of our associations, first of all, we do promote the establishment of the register of wills and European succession certificates, but this came later. But we started actually with the register of wills, and we do promote their networking. Of course, we answered to calls for projects for European institutions, and we fully encourage the creation of a network between the European bodies of notaries or other bodies which are administrating the national registers and allowing secured exchanges. Not all the registers of wills are administered by the notaries. Some of them are administered by the state. And this is why I'm saying that I'm not talking about the notary bodies. We have some members 21 actually. All of them, or mostly, are also members of the Notaries of Europe. We have an exception, Swiss, and we have a partner which are our colleagues from Estonia. We're starting with Germany, Austria, Belgium, Bulgaria, Croatia, as you see, Spain, France, Greece, Hungary, Italy, Lithuania, I don't know the phrase, sorry, Luxembourg, Malta, the Dutch, Poland, Portugal, Romania, Slovakia, and Slovenia. Not all of them are interconnected, but all of them are members. We still wait for another colleagues to join us and to make our service more fruitful. What do you do? What do we do? First of all, we have a legal framework, and we use the Basel Convention relating to the establishment of a system for the registration of wills from 1972, and the national registers interconnected at the RED platform must be a signatory state of the Basel Convention, or if they are not, then they have to sign, let's say, a paper in which they declare they respect the main principles of the convention. Of course, we are based on the mutual trust among national registers, and that means that the information regarding the death received from another registers comes from a truthful source, which is the notary. So, we are a network which is aimed to benefit for the European citizens and, of course, for the professionals. First of all, it benefits to the testator, because registering his will, he will be sure that at one point when he will die, it will be able to be found in many European Union states, and not always, because, as I said, we are also having the Swiss as partners, and you can find also last wills in Switzerland. Of course, it also benefits to the heirs and the legatees, because you will be able to find the testamentary provisions they can rely on, and it benefits to the legal professions, because it helps you to know either you have a certificate of successions in Europe or a last will which has been issued in another member state. Which are those, I previously showed you the members, and those are the registers who are interconnected. We have two types of interconnection, which is the one for the testaments and one for the European Certificate of Succession. We don't have too many about the last type, the European successions, but we still hope that there is a lot of space for improvement. But 14 members are interconnected regarding the last wills, and it's for sure that if you have a query in those states, you'll get an answer if there is a last will or not. So, which are our tools? First of all, we are sure that all legal, let's say, deeds affecting the devolution are registered, but there is a, let's say, I have to mention that we do not register the last will by themselves or the content of it. We do just register, or we, how do you say it? We have the access to metadata, just about the here or where you can find the last will. And of course, the registration has no validity on the act, and we do assure the confidentiality and about the existence of and the content of the will. Of course, the content of the last will is always just at the issuing authority, which is the notary. We do respect the principles of the conventions of bail, which means that recording of the reference to the holder of the will, and we do not file the will in the register, as I previously said, and there is the obligation to register the will in the national register itself, because we just interconnect the last will registers and the consulting of it. And of course, there is no nationality requirement for registered wills in the National Register itself. Which are our tools? We do have two tools, which the one is RERT and the RERT Lite. The first one is an automated interconnection of the registers, and the second one is through a contact point. It's not automatically, it's done by a local correspondent. But of course, in order to respect the different national legislations, these tools can only be used to query the other European registers. We have, for example, the Austrian example, as I said, where the notary just can query the register. Actually, you can query us, and we cannot query you. Yes, but we have to improve that. Yes, because now there is actually the fact that the Austrian are helping the courts, and they are the so-called Gerichtskommissare, and then this is why they are not doing it directly. We have some figures. Well, since we have been established, we have always better figures, and those are just, you can compare them between 2021 and 2022, and you see there is always an increase in figure. Now last month we had almost 4,000 of queries, and that's actually a proof that in 4,000 cases, succession cases, the legal professionals could be sure that there is or there is no last will, which of course can help them a lot of when setting these succession cases. And those are the positive answers. Well, it's almost steady, because it has decreased a little bit in September, but in August and July was a sort of increase. Of course, May was the best rate. Well, we also have a website for providing information for the citizens and the legal professionals. It's, of course, it's arert.eu or enra.eu, where you can find our members, or we have practical sheets. I will tell you about it. So we have practical sheets which are updated once a year. Of course, they are downloadable, and we have two main themes: how do you register and search for a will in the various national registers, and what to do once the will is found. And as you see, we have them available in English, French, and German. And of course, if any other country wishes to have it translated, with their help, we can provide it. Thank you very much.
Thank you very much to the president of ENRA. And now we are going to move to the part of the seminar which is dedicated to the practices, national practices. So Lithuanian experiences in the area of regulation application will be covered by legal advisor at the Lithuanian Notariate, Eglė Čiplinskienė. The purpose of my presentation today is to review Lithuanians' experience in applying the EU succession regulation. It should be noted that the number of succession cases with a cross-border element in Lithuania is relatively still small. Statistically, about 50,000 national succession certificates are issued per year in Lithuania, while the highest number of European succession certificates was 7 a year. Of course, not all inheritance cases, succession cases with a cross-border element result in the issue of a European succession certificate. Some of the cases with a cross-border element concern non-EU countries, but the application of the regulation raises questions for notaries, heirs, and others alike. When the succession regulation became applicable, one of the main questions for Lithuanian notaries was whether they were to be considered courts within the meaning of the regulation, and consequently whether they were subject to the rules of jurisdiction set out in the regulation. This issue was the subject of a number of discussions with the Ministry of Justice, and then it reached the Lithuanian courts. In 2019, the Supreme Court of Lithuania asked the Court of Justice of the European Union for a preliminary ruling on how to interpret provisions of the succession regulation. And the situation was as follows. After the death of his mother, who lived and died in Germany, the applicant applied to a Lithuanian notary with a request to open up a succession case. The deceased had assets in Lithuania, which she had left to her son. The notary refused to open a succession case referring to the regulation on the grounds that the deceased habitual residence was in Germany. The Supreme Court of Lithuania was interested in the interpretation of the status of the notary and the legal effect of notarial acts under the regulation. In the light of the decision of the Court of Justice of the European Union, the Supreme Court of Lithuania has clarified that since Lithuanian notaries are not competent to decide on the issues that gave rise to the dispute between the parties and have no right to establish the factual circumstances that are not clear or obvious, or to decide on the disputed facts, the issuance of a national inheritance or succession certificate by the Lithuanian notaries does not constitute the exercise of judicial functions in Lithuania. The functions performed by notaries in issuing a succession certificate do not constitute the exercise of judicial functions, and the rules of jurisdiction laid down in the succession regulation do not necessarily apply to notaries in Lithuania. The court also held that in order to establish uniformity in the resolution of succession cases, the legislator could introduce a provision obliging Lithuanian notaries to follow the rules of regulation, the rules of jurisdiction and the regulation. But in the absence of such rules, notaries in Lithuania must follow the rules of national law in succession cases with a cross-border element. Although the rules in Lithuania regarding the notary who is to conduct the succession procedures are similar to those in the succession regulation, as a rule, the notary of the deceased last habitual resident is conducting the succession proceedings. There are still some issues remaining. In particular, Lithuania does not provide for the possibility for the parties to agree on the succession in a state other than the state of the deceased last habitual residence. Regulation, however, does provide for this option. It should be noted that the Supreme Court of Lithuania has held, although the recognition of the jurisdiction of the court does not unequivocally imply that the parties may also agree to settle the succession out of court in a state other than that of the deceased last habitual residence, the succession regulation must not be interpreted as preventing the parties in the state of their choice from settling the succession out of court if it's possible under the law of that member state. The situation arises also that the notary in Lithuania decides whether he is competent to accept the heir's application for the acceptance of the inheritance in accordance with national law, but in the event of a dispute, it is for the court, which is competent in accordance with the provisions of the succession regulation, to decide on it. The Supreme Court of Lithuania has also ruled in the case on the legal validity of the national succession certificate issued by a Lithuanian notary. The court held that this document fulfills the elements defining the authenticity of an authentic document, confirms the heir's ownership of the property referred to in certificate, and is the basis for the registration of the heir's ownership rights in public registries, and therefore, for the purposes of Article 60 of the regulation, an authentic document which is enforceable in the member state of origin. Another topical issue that has arisen in Lithuania as a result of the application of the succession regulation is the registration of property rights in the registry if a European succession certificate does not contain all the data required for the registration under national law. Under Lithuanian national law, for ownership rights to a real estate object to be registered in the real estate register, the document must contain details about the real estate object. The registrar refused to register the title on the basis of a European succession certificate issued in Germany because the certificate indicated that the person was the heir but did not provide any details of the property inherited. The applicant filed an appeal against the actions of the registrar. The Supreme Administrative Court of Lithuania again referred to the Court of Justice of the European Union for a preliminary ruling on the question whether the provisions of these succession regulations are to be interpreted as not precluding the provisions of the law of the member state where the immovable property is situated, according to which, on the basis of a European succession certificate, it is only possible to register the right of ownership in the property register, provided that all the particulars necessary for the registration of property are included in the European succession certificate. So the case is pending before the Court of Justice, but the Advocate General's opinion is already available. The Advocate General distinguished between two aspects of the case: whether the estate must or may be indicated in the European succession certificate, and whether the registrar may refuse to register the property on the grounds that the property is not indicated in the European succession certificate. In the Advocate General's view, it is not necessary to specify the assets in the European succession certificate if the heir is universally entitled heir. As regards the second point, in his view, the Lithuanian authorities have all the information they need to register property in the real estate register. That is, the authorities can establish that the property in question belongs or belonged to the deceased, and they can verify by means of the European succession certificate that the applicant is an heir. The Advocate General therefore proposes to answer the question put by the Supreme Administrative Court of Lithuania that it is precluded to apply provisions of national law under which immovable property acquired by the sole heir in accordance with the principle of universal succession may be registered in the real estate register of the member state in the territory to which it is situated on the basis of a European succession certificate, but only on condition that the certificate contains all the particulars of the immovable property. But again, we are still waiting for the court's decision because this was just the Advocate General's opinion. Of course, not all issues raised by the succession regulation reached the court, and in particular the Court of Justice of the European Union, Lithuanian notaries, heirs, other persons dealing with the regulation have questions. And I will briefly mention some of them, things that we are discussing. So one of the questions we are discussing is the establishing the last habitual residence of the deceased. So the provisions of the regulation on determining the last habitual residence are not very specific. So in Lithuania, notaries face problems in determining the habitual residence of the deceased. This is especially true given the fact that many people left Lithuania for other countries and have done so for economic reasons. They've lived for many years abroad and have no plans to return to Lithuania, but they have heirs that are often their parents living in Lithuania who find it easier and cheaper to handle succession matters in Lithuania. but the Lithuanian notary cannot be sure that the deceased person has not been married abroad, has no children, has no property, and he's not the center of his or her family or social interest, as claims by those who have applied to a notary in Lithuania. The Supreme Court of Lithuania has ruled that the notary must be provided with sufficient and obvious factual data confirming that the place of origin of succession is in the territory in Lithuania. And if the place of origin of succession is not clear, for example, the person has declared the place of residence in another state, but property and the heir are in a different state, the notary should explain to the heir that they have to go to court to establish the last habitual residence. Another thing we are discussing is the application of the regulation according to the deceased, to the date of the deceased. For example, a Lithuanian notary had encountered a situation where in the course of the succession proceedings of a deceased who died before August 17, 2015, persons claim that the interested authorities of another European Union country require the presentation of a European succession certificate. There are also discussions on the application of regulation in cases where successions involve third countries. So we're still debating whether the provisions of the regulation on the applicable law should be applied to succession proceedings involving Lithuania or other states which is not members of the European Union. So this is briefly about the experience of Lithuanian notaries and questions that they have here in Lithuania. And I'm glad that today we have the opportunity to share the experiences and to find out how notaries in other countries live and what they have to deal with, whether their problems are similar or not. Thank you. Thank you, Egle. Because the seminar is intended to share experiences through practitioners who apply the regulation in practice. Participants of the seminar can ask questions to the presenters, to the speakers, and if they want to share something, if they want to share practical aspects, they can do so, and we will have the time to do so. Now it's the time for you to think about questions that you're going to ask later on. And now I would like to give the floor to a presenter from the Austrian Chamber of Notaries, Stefan Matik Anjani, who is going to talk about the practical application matters of the regulation in Austria. The floor is yours.
Is okay? Okay. Yes, good morning to everybody, and thank you for having invited me to present the Austrian experience with this regulation. It's really an honor to be here, and also it's a pleasure, I have to say, for me to work and to be able to contribute to this fantastic project, which is the MAPE project, and it's really it is an excellent project because the notaries of Europe are a driving force for the development of EU law, in fact, with such a project. It can be the basis for future developments. It's very important, I think, for the notarial profession in Europe. But now, as to the Austrian experience, I would like to share a few thoughts with you. First of all, in Austria, as you have heard earlier, when Gianmarco Caramone was referring to the Justice Without Litigation project, Austria is among those countries in which succession procedure is a court procedure. In fact, it's a judicial and non-contentious judicial procedure. And the notary plays a very important role here because notaries act here as agents of the courts, so it's called court commissioners, and they don't act as notary in that procedure. They are court agents, and so most of the procedure is done, in fact, by the notary, except the very final decision. This is still done then by the judge, but it's only a formality. So on substance, everything is done by the notary. And that's the reason why, because in fact this is all succession procedures are handled like this. That's the reason why there's really extensive experience in Austria by the notaries with not only the succession procedures in general, but with the succession regulation. And by the way, this is an important element also to be considered in the succession regulation itself, because there's a definition on the term court. The term court has been broadened up by the succession regulation to cover such, let's say, outside court institutions like the notaries acting on behalf of the court. So that's a very interesting aspect. Now, I've selected a few topics to share with you. I have to say, in general, of course, the experience is a positive one, and we are very happy to have the succession regulation. It has facilitated a lot of things in handling cross-border successions, and but we have a few issues where we have also challenges and difficulties, and I wanted to share a few thoughts with you. The first issue concerns the land register. This is a big issue for, I think, almost everybody throughout the EU, the land register and how to deal with it. And for us, it was also some kind of a problem. In particular, we have, there are countries in which it is not required to mention, to refer to the real estate property in the documents. So, for instance, it's the case for Germany, and the question was, when such document, the German Erbschein, for instance, or a ECS from Germany is coming to Austria, is presented to the Austrian court for the transcript of the land register. Then there was the issue that the court official said, we don't have the reference here, so we cannot proceed with the transcription in the land register. This has been solved. Fortunately, this problem has been solved by two Supreme Court decisions, Austrian Supreme Court decisions, both from 2017. In fact, the Supreme Court has decided in one case, both cases are in relationship to Germany. So in both cases, it was decided that it is not necessary anymore to have a reference to the property in the document, and I will explain to you why. In the first decision, this was an ECS, a European Certificate of Successions, presented to an Austrian court. The Austrian court has refused, and this was challenged, and the Supreme Court has said, okay, it is not necessary anymore to mention the property. Why? Because the succession regulation does not foresee it. In Article 68, it is not foreseen. And because it's not foreseen, it's not required. That's why the courts in Austria must proceed despite the fact that it is not mentioned in the ECS. There's no reference. It is only mentioned that the heir is the heir, or the legatee, and that's sufficient. And that's interesting, I think. So that has somehow broken the barrier, the they've broken the problem, so there's no problem here anymore on that side. The other case pertained to German Erbschein, this national document issued by German courts, and here it was the argument was that because German law was applicable, that because of the immediate the immediate succession at the time of death, all the rights have been gone to the heir, have been transferred, and this is based on German law, and that's why this was also possible here to proceed with the transcription of the register. What is very important is that the Austrian Supreme Court has also stated concerning to the case with the ECS that the ECS, the European Certificate of Succession, must be an effective document. Yeah? It is very important that it remains effective. It's otherwise this is senseless. If you cannot use it, and if people present the ECS and cannot do anything with it, this makes no sense. It's not in the spirit of the regulation. Yeah. Another issue concerning the European Certificate of Succession was a case which was brought forward as a preliminary ruling request also by the Austrian Supreme Court to the European Court of Justice in Luxembourg. This was, in fact, it was about the certified copy of an ECS. This certified copy was issued in Spain by a Spanish notary, and there was, there's this case there's this box where you have to mention the time validity, the time limit until when until what date the ECS is valid, and it was mentioned by the Spanish notary unlimited. And so the question was what to do with it. How is it valid? How long is it valid? The European Court of Justice has stated that in such cases it is valid according to Article 70, paragraph 3 of the succession regulation. It has to be assumed that it expires after 6 months. So 6 months, the 6 months validity is assumed in that case. That's interesting. And the second issue here in that same case was the question on as to whom the ECS produces effects, and can a person not requesting the ECS, yeah, as such, not applying for the ECS, can effects be produced as to this person? This is the case for all persons who are named in the ECS. So whether they apply for it or not, the ECS produces effects to all persons which are mentioned in the ECS. This was also the Court of Justice in Luxembourg stating it was the case C301/20. You find it in the slide. Then there was a second case brought forward to the EU Court of Justice. So we also, as Lithuania, I think you have the Lithuanian courts have brought cases twice also it's the same for Austria. And the second case was about the qualification of a gift upon death, a donation upon death, falling under the concept of agreement as to succession. And so this has been also confirmed by the Court of Justice. So these are two interesting cases. Now, we have practical difficulties with certain issues, and I come back to land registers. We unfortunately have, I have to say, it's a pity, but we have a problem with the German land register. Because the German law on land registers require as a document to be presented for the transcription of the register, either a German document, the Erbschein, or an ECS, European Certificate of Succession. This raises problems for our practitioners, for us, for the Austrian notaries, insofar that national documents which we produce, and at the end of the succession procedure in Austria, this is not an authentic instrument, it is a decision, a court decision. This decision cannot be used at the German land register because of this situation, unfortunate situation, which we think in the German Grundbuchordnung. Instead, there must be a European Certificate of Succession be presented as an alternative. It works only like this. This, of course, means that people, the persons presenting national documents to the German register, they are frustrated and they have to go back to the notary in Austria to ask for a European Certificate of Succession. This takes time, it's costly. So this is not an ideal situation. We hope that this can change at a certain moment. Yeah, and we think also that this is not. It is contrary to, in fact, to the concept of the European Certificate of Succession, which is an optional instrument. This is explicitly regulated in the succession regulation. It is an optional instrument, and this makes the ECS. This situation makes the ECS rather a mandatory instrument, I would say, or it goes into that spirit rather. So, what's important, and I think that's important also for the MAPE study, national documents need to circulate. We need to ensure that national documents can also circulate. There is a problem here. We have a comparable issue, unfortunately, also with Croatia on that point. It is maybe not as, let's say, pronounced as it is in Germany, but we know that from practical experience that the ECS is required in Croatia, and here also we should come back to the spirit of the regulation, that this is an optional instrument, in fact. By the way, that might be a reason. I look to Patrick Waterley, the scientific head of the MAPE project. That might be one of the reasons why we have such a high rate of ECSs issued also in Austria, because of the need to present them in certain member states. Concerning the ECS as such, when we see ECSs coming in, there is a problem in ECSs coming presented in Austria with a lack of mentioning property, despite the Supreme Court legislation which I mentioned earlier. It is, of course, helpful if the property is mentioned. Yeah, not only real estate, but also other property. So that's an issue. And of course, it is felt, the ECS as such, and that's probably not a surprise to all of you, that's a bit complex and burdensome to fill in, and so yeah. So there's probably room for improvement to facilitate things a bit, yeah. I think here some that there can be work should be done on the ECS. Now we have a particular issue also with foreign banks, insurance companies, and social security institutions. There is regularly the issue that these institutions, banks, insurance companies, social security institutions, they do not trust that an Austrian notary is an Austrian notary and that this Austrian notary is even a court commissioner. Yeah? So they want the proof. Then in Austria, the issue is that there is nothing stated by the court that the notary is a court commissioner. We only have two things. We have the law, so it's an ex lege competence, that it is like this. And we have what we call the Verteilungsordnung, meaning that there is, at the beginning of the year, it is determined which notary is competent for which succession case, in which area, in which street, etc. And the territorial competence and the time of death of a certain person. And it is a hassle, and it is really difficult because people lose time to explain to banks, insurance companies, etc., what the position of the notary is. And it is not rare that such, let's say, exchange and procedure takes up to 4 to 5 months. Yeah? So can you imagine this loss of time only because of that? So something should be done here to improve the situation, and it's a clear lack of trust. Then, of course, then we have another issue. It was raised also yesterday in our meeting, working group session, that we have difficulties with the jurisdiction rules. But we have here problems. It's not only about notaries acting as courts or non-courts, or authorities being courts or not courts. This is an issue because different rules apply. For the one, the jurisdiction rules apply, for the others not. But there is also another issue, even for notaries acting as courts, falling under the definition of court. We have frequently, quite frequently, the situation that the jurisdiction rules of the succession regulation are ignored. So meaning that we have the situation that normally, according to the regulation, Austria would have jurisdiction, but in the other member state, where there's maybe property located, very often it is because of property located there, the authority, which can be a notary acting as court commissioner, has already proceeded. And there is a decision there. So what to do in such case? There's nothing in the regulation to solve this issue. The problem is that such decision of a non-competent court or non-competent authority has to be recognized. It has to be recognized. Yeah? There's no other way. And so we will have to find here some solution probably for such cases when non-competent authorities decide. Yes, then we have another issue. This is again linked to registration of land in Germany. We have the Kubitzka case. It's about legatees having direct rights in the succession. You remember the Kubitzka case with the vindication legatee and damnation legatee, and so whether it's direct right or not. In Austria, we have the system that the legatees have no direct rights, so it's like in Germany, and the problem is now what can we do in such situation, because with the issuance of an ECS for an Austrian legatee, because the ECS can be issued only for heirs or legatees having direct rights. Now, when I come back to the problem which I have explained earlier with the German Grundbuchordnung, the law on the land registers, where you have to present an ECS. So for an Austrian legatee having no direct rights, but only indirect rights, the person cannot obtain an ECS. So we are blocked somehow here. Cannot present the national document. So what to do? For the moment, we don't yet have a clear answer. You see, these are all situations where we face, unfortunately, legal uncertainty. That's a problem. So that we really have room for improvement. Another issue of legal uncertainty is the relationship between Article 25 and 23 of the regulation. Article 25, Article 23, it is about the scope of the applicable law, and 25 concerns the agreements as to successions. And here we have, let's say, an issue with waivers of the reserved share in particular. People making a waiver on the reserved share. The problem is the following. This is authorized in some member states, and in others it's not possible. In Austria it's possible. It has to be done by notarial act. In Italy, for instance, this is not possible. Now, we have the problem that we could face here situations such as, I give you a practical example. Let's say an Italian testator with habitual residence in Austria who did not make any choice of law in favor of Italian law, for instance. He did not make it, but makes a waiver on the reserved share in Austria. Now, at the time of his death, he was habitually resident, he became a habitually resident in Italy. What happens there? Is then, because then, of course, to the succession, you would need to apply Italian law, and it could be that this waiver will not be valid under Italian law. The other example could be the Austrian national residing in Austria for many years, making also such waiver without choice of law and so, but then moving after a certain time to Italy and dying in Italy, having had in the meanwhile habitual residence in Italy. It's the same situation. So here there is this problem of whether retrospectively something like this could become invalid. Yeah, retrospectively. It's a question, and it's a source of legal uncertainty. And my colleagues, in particular Alice Perscher, who is a member of the scientific committee of the MAPE project, she told me that this is really a very crucial topic for Austrian notaries, because and for the people, of course, making such waiver. There could be an interpretation here, which I could share then with Patrick, to eventually solve this issue, but we don't know. We don't have a clear result here. Yeah? Yeah. Yeah, that was it. That's it already. And time has flown very quick. We were flying very quick. And yeah, thank you again. Yeah.
Thank you very much.
So thank you to our Austrian colleague. Now I would like to ask all of you, do you have any questions? any comments? Do you have maybe insights? You can ask questions to our speakers. If you want to speak up, just raise your hands. It seems that we don't have questions for now for this session, so I will invite you for a coffee break. So we have half an hour for a coffee break, and then let's go back to the room after half an hour. Thank you.
Welcome back. We will now move on to the part of the seminar for covering the project on the evaluation of the regulation. We are very happy that the results of this project, which is of overwhelming importance for Europe, will be presented during this seminar. And for that purpose, we have the head of the project, Marian Sevendik, and Patrick Watley, academic advisor of the project MAPE Successions. I give the floor to Marian Sevendik to present the results and to present the questionnaire and the information.
Merci. Chers membres de la Chambre des notaires de Lituanie.
Thank you. Dear members of the Chamber of Notaries of Lithuania, dear Egle, colleagues, participants, first of all, I would like to thank President Marius Stračkaitis and the Chamber of Notaries of Lithuania for welcoming us in this European conference as part of the MAPE project concerning the succession regulation in force since August 2015 in 22 member states. In my introduction, I would like to briefly remind you of the context of MAPE project to complement Gianmarco's remarks. Why is this project important? In order to meet the main objective of the European institutions in the field of cooperation in civil and commercial matters, that is the principal objective, to properly implement the existing EU rules. For this reason, the EU lacks information on how EU rules are applied by member states, and information on whether member states actually use these instruments. In this context, the Union therefore has launched the MAPE project to assess the application of the regulation and highlight any practical problems encountered in the settlement of international succession cases in the 22 member states. This conference will give us the opportunity to present the work carried out for almost 2 years. First of all, I would like to introduce to you the working group. Gianmarco, you have already talked before. So there were 2 committees. There's a pilot work committee and
Présenté par son président Octavian Rogajanu.
And another committee presented by Octavian Rogajanu. There's Malta Council, German Chamber, the Lithuanian Chamber of Notaries, CNUE members, the Succession Working Group, experts, statisticians, and IT experts, as well as our researchers. Professor Brigitta Lerger from Austria, Dr. Patrick Watley, who has covered the analysis, and Dr. Pierre Calais from France. A steering committee and a scientific committee. These were the 2 committees. We had a meeting with the steering committee and scientific committee and understood that uniting those 2 committees together would be more productive. So we have a mixed working group, so these committees could work closer together and reflect the different views of the key actors and stakeholders in the application of the regulation. I remind you that this project consists of 5 phases. You can see those on screen. During the first month of the project, the members of the 2 committees worked on the definition of a monitoring and evaluation methodology and the criteria to be considered for data collection. During the second phase of the project, it was important to map the information that we needed. During phase 3, we searched for methodology, and we have now a grid for collection of data, which will guide the process of data collection. And next, we covered the general questions, the competence, the applicable law, the authentic instruments, and of course the European Certificate of Succession. During the fourth phase, which has just completed, we collected data. We began that in spring 2022, and we aimed to collect data on the application of the regulation so we could conduct our study. After 2 years, we can now present the results. They will soon be presented to the European Commission. The results are a fruit of 3 questionnaires. The 3 questionnaires which were targeted at target groups to receive qualitative and quantitative information. And I will cover the 3 questionnaires in brief so that you have a general outlook of what were the questions and what were the targets. And Professor Wotle will present the analysis of these questionnaires and the information received via these questionnaires. Questionnaire number 1 was targeted at everyone. It was online, and it was designed to be distributed to all notaries in the 22 civil law countries of the European Union. The questionnaire was translated into 19 languages and made available online. The notarial chambers of the 22 above-mentioned countries took over the distribution of the questionnaire to their members. That was an anonymous questionnaire, and the questions were on the self-assessment of the notary, which is very practical, and also the evaluation of the training and the practice of the notary, the competence of the notary. We can see the figures on the slide, the applicable law, the authentic instruments, and the European Certificate of Succession. I will cover, without analyzing, the answers to the questionnaire questions. I will not comment on the figures because I need to explain why we have those figures for each of the countries. And Mr. Patrick Wotle will talk about that later on. In questionnaire number 2, we had questions for experts. Every member state had a mission of determining the experts. 2 or 4 experts per question, per country. The questions were open and covered the practice of notaries and whether the regulation covered all the practical needs of the notaries and which needs were not covered by the regulation. Applicable law, authentic instruments, the European Certificate of Succession were the targets of the questions. Questionnaire number 3 covered the questionnaire for institutional actors, namely all chambers of notaries or other institutions. Now, this questionnaire had a target of getting information, quantitative and qualitative information and data on other aspects such as the applicable law, authentic instruments, the European Certificate of Succession. All the data have already been analyzed by our researchers. We have conclusions, suggestions, which will be soon presented to you by Professor Wotle. The conclusions will be also presented probably, because I don't know the dates, but probably we'll have a meeting at Malta. And the final presentation will take part in Brussels in March. And finally, The data will be provided to the European Commission so that the Commission will be able to revise the succession regulation planned for 2025. Finally, the methods used for data collection, evaluation and monitoring of the operation of the succession settlement could be reused as part of evaluation of other regulations. So this will be a useful and precious tool. And I give the floor to Professor Woodley for his analysis part.
Thank you very much, Marianne. And while I'm trying to see how to close the presentation and open my new one, but I'm sure the mouse is a bit sleepy, I would say. But while this is being done, I'd like to thank the Chamber for this very kind invitation and the wonderful organization. I'm very glad to be here with you today, to be able, on behalf of the academic committee, to present the first results of our MAPE analysis. And I insist and I stress on the fact that I'm doing this not on my own, but I'm speaking here on behalf of my colleagues Brigitta Lürger and Pierre Calais. And I'm, yes, almost there. If you bear with me, here we go. Marianne has just reminded you or explained to you that in order to collect data on the actual application of the succession regulation, we used 3 different tools. I will not come back on the details. Marianne has explained that these tools were targeting different audiences within the notarial world. That's one of them was a very massive tool online. The other one was an tool aimed at expert notaries. We have results now, and during the last couple of months, my colleagues Brigitta Lürger, Pierre Calais, and myself, we've been trying to analyze these results. And this is what I will present to you. Let me stress that this is a first attempt at analyzing a massive amount of data. So we have analyzed the data looking at the 3 different tools, but I'm sure that in the coming weeks, we will refine the analysis and we will certainly come across new findings. What I will present to you today is not an analysis tool by tool, but let's say a cross-tool analysis. I will pick information and data from any of the 3 tools and put them together so that we can focus not so much on how we got the data. Was it through an online questionnaire or a questionnaire aimed at expert notaries, but which data did we get? And what does it tell us about the regulation? We received or we collected quantitative data, numbers, figures, and qualitative data. So we work on the two sides here. Looking at the quantitative data, we have both quantitative data at the European level. You know, if we put the 21 member states together, we have calculated averages, and we have data at the national level. For this presentation, I've chosen to work with the European average and not to focus on the specific situation of some member states. This will certainly be included in the final analysis, where we will certainly add information on specific situations of member states, but for time reasons, you will understand that. I will not do so today, and I will focus on the main issues, let's say, highlighting some of the main results of our analysis. Now, this is the first result, and the question here was, do notaries actually use the regulation, or has it remained an instrument adopted somewhere in Brussels, which has been published, with many books published on this, but which notaries live in your drawer? This was a question. Why? Well, because in all member states, we had succession law for centuries sometimes. We also had cross-border rules on succession law. So this was new. And we wanted to find out whether notaries embraced the regulation, yes or not. And did they do so massively? Or was it, let's say, a niche phenomenon. You can see the answer, if you look at the blue side of this pie, 73% of the notaries which responded to our online survey have indicated that they have applied the regulation. 73%, I think we can say it's a resounding yes to the question. The regulation is alive, it is being used in member states. Now, there is diversity. Now, Europe is very large, so you cannot say that the situation is identical in all member states. In some member states, we have even a higher percentage than 73%. In 5 member states, more than 90% of notaries have indicated that they have used the regulation. So there we can say that the regulation is applied all over the member states. In a number of member states, the percentage was a bit lower. In Greece, for example, we have around 25% of notaries who have used the regulation. So there is diversity. And another source of diversity is the fact that we also asked notaries how often they use the regulation. Was it something they used exceptionally, occasionally, once in a year, once in a lifetime, or was it something that came by in their practice on a more regular basis? And here we find that 26%, a quarter of notaries apply the regulation on a regular basis. The majority, 61%, indicate that they apply it rarely. Rarely, one could say maybe once or twice a year. I would say this diversity is certainly not surprising, because if you look at practice of notaries, the practice is very different. Not all notaries have every week or every month clients coming with assets abroad or children abroad or foreign nationality. So it's obvious and it's not surprising that the reaction and the response we received from notaries was, yes, we apply it, but not in the same way. I think the lesson we can draw here is that the regulation is applied. It's not a paper instrument. It is applied. It's not a niche, you know, for specialized notaries with a couple of notaries in every member state. No, it's applied widely, but not with the same frequency in all notarial practices. That's the first lesson we can draw from our data collection. Now, a second lesson, which is a little bit less positive, I have to say, is that we also asked notaries whether they used some of the tools which Gianmarco has referred to, which CNUE, with the help of national chambers, has built over the years, and which aim to facilitate the work of notaries. You know the European Notarial Network, you've received the leaflet, and you know you have to register if you're not registered yet. You know the European Directory of Notaries. Are these tools being used? Well, what do we learn? I would say the results are rather disappointing on the use of these notarial tools, because 83%, it's a very large majority of notaries, have said that they have not yet used the European Notarial Network. And only 44% of notaries are aware of the existence of the European directories, a directory of notaries. What does it show? Well, it shows that there is room for improvement. These tools should be better disseminated among notaries. How do we do this? That's another question. I think it's time for the CNUE, together with all the national chambers, to reflect on what additional effort could be undertaken to make sure that these tools reach their goals, facilitate the work of all notaries. We also wanted to know what was the general impression of notaries when using the regulation? Was it a positive or a negative impression? And whether it was positive or negative, why? Why did notaries have a positive, let's say, feeling towards the regulation, or why did they have a negative impression? And looking at this question here, you know, how has the regulation transformed or changed or modified the practice of notaries? I have to say the majority of notaries were positive about the regulation. This is the, let's say, an overall feeling we have when reading both the response to the massive online questionnaire and especially the almost 70 answers we received from expert notaries. 70 answers, 70, coming from all member states. Well, the general feeling was the regulation is seen as a positive development for cross-border practice. And I think it was not granted. It was not granted. Again, the regulation could have remained the sleeping beauty I would say. It's not the case. Now, going further, why is the regulation perceived as being a positive development? Here you find the list of, let's say, the reasons why notaries, the experience of notaries is positive. And the list is hierarchical. I'm sorry, it's a very difficult word even in English. You understand that the first item on the list has more weight than the last item. It's a bit surprising to find that the ECS is seen as the most positive item, explaining why notaries are positive. It means that, yes, notaries in general found that the ECS made a contribution to their work on the daily practice. These 5 items, I will not go through in details through them, but it's nice to know that among these 5 items you find and the European Certificate of Succession and the 2 main rules of the regulation. The regulation is premised on the fact that a succession will be governed by the law of the last habitual residence, but that everyone can make a choice of law. Well, we find these 2 items as positive elements. At least that's the feedback we get from notaries. Now, not everything is positive. You know that. Notaries also came back to us telling us that there were difficulties, problems in practice. And you can see here an overview of the main problems faced by notaries. And it's not surprising. Again, there is a hierarchy in the sense that the item on top of the list is the most problematic. And it's not surprising that it's already been touched by the speakers of this morning. Both speakers talking about their national experiences have told us that there is an issue about registering immovable on the basis of an ECS in property registers. The lack of definition of the habitual residence is also being touched by Egle this morning. So yes, these are issues. It's also interesting to realize that among these issues, issue number 3 and 4 in the middle, they're not specific to the regulation. The difficulty of taxation of succession and the problem of finding out what foreign law says, well, this is something you could find in other fields, in matrimonial property, but also when you sell an immovable, you know, if the seller is established in another member state, what about the tax aspect of the sale? Finding out about foreign law, it's a general issue of cross-border matters. So these are not specific to the regulation. It also means that when looking forward and thinking about possible evolution of the regulation, we would need certainly to focus on other issues which are specific to the ECS and which can find a solution in the ECS. Let's not be too ambitious. The problem of finding out the content of foreign law vastly exceeds succession matters. Now, I will continue by listing for each main topics, let's say, the most important finding. We had the possibility yesterday to have a longer discussion and during which I went in more details in the findings. For today's purpose, let's be focused on 1, maybe possibly 2 findings for each topic. And let's begin by looking at rules of jurisdiction. We've heard already a lot about the rules of jurisdiction and the difficulties they raise. One of our findings in that respect is that Article 5 is not widely used. You may remember that Article 5 is quite innovative in the sense that it creates the possibility for, let's say, the family members of a deceased, the heirs, surviving spouse and children, to agree on the court having jurisdiction, provided the deceased had made a choice of law. It's a complex rule. You have to apply Article 5 together with Article 7. It's also quite complex because all parties concerned have to agree on the choice of court. So we wanted to know, have you come across a choice of court? And the answer is, well, not very often, because if you look at the results, only 16% of notaries have said that they have come across a choice of court. So apparently Article 5 is not widely used. Now the question is why? Why is it that Article 5, which sounds promising on paper, why is it that it's not being used? Is it not being used because it's too complex? You need to find out who are the parties and get their agreement, while Article 5 could precisely be useful if parties live in different member states, so it may be difficult for the notary to get in contact, get in touch with all the family members and get their agreement? Is that the problem? Or is it because we don't need it? Is it because the other rules of jurisdiction, and mainly Article 4, habitual residence, provide satisfaction? That's an open question. Our analysis does not yet allow us to provide a final answer to that, but certainly I think it's a point, an element, an item on which we should be reflecting further. Why is it that this very innovative possibility is not being used by, or at least not being extensively used in notarial practice? Another point of attention concerning rules of jurisdiction, there's been some allusion to it this morning. 37% of notaries, which is quite a large, high number, have told us that they have been faced with parallel succession proceedings in member states. Now, we should be careful when reading about this, because what do we mean exactly by parallel proceedings? We could mean a situation where two courts are seized. My understanding is that this would be a rare occurrence, and we have a solution in the regulation, Article 17, lists alibi pendants. Now, I know it's not easy to apply, especially because you have to first figure out, am I a court or not? We've heard about this morning, am I a court? And I'm glad that Supreme Courts have provided guidance on that. So if the problem is two separate court proceedings, we already have a solution, not a perfect one, but we have a solution in the regulation. But it could be, we could mean parallel proceedings where we have two notaries in two different countries which have been asked to sort out the succession. Are these parallel proceedings? Yes. Well, they're parallel proceedings, but they could in themselves also be quite different. You could have a situation where one of the notaries will be a court commissioner and the other not. I'm sorry. I'm trying to find the mouse, but apparently the mouse is playing hide and seek, as one says, a little bit. So oh yes, here it is. So you could have a situation where one of the notaries is a court commissioner and the other not. You could have a situation where the two notaries are, let's say, traditional civil law, French type of notaries, not appointed by the court. So there is a variety of situation of parallel proceedings, which means that the solution could be different depending on which situation we face. One possible solution is we could try to make more information available on the opening of succession proceedings in other member states, especially when succession proceedings are opened by operation of the law, ex officio. That's problematic. But I see you wondering, how do we make more information available? Do we need a pan-European register of succession proceedings? Is that not a little bit too ambitious? We're not yet in the stage of developing final solutions. Let me come back to the finding. I think the finding is we need to flag out parallel proceedings. It's more prevalent than expected. 37% again of notaries have had difficulties with this. We have to be concerned and reflect upon possible solutions, and not one, but possibly several solutions, because again, we could have different types of parallel proceedings. Let's turn to choice of law, which was one of the major innovations of the succession regulation. There were not many member states where you could choose the law on your succession, and Article 22 allows this. Now, is this being used, or again, has this remained a dormant mechanism? Well, 68% of respondents said yes, we use it. That's a large majority. There is a comfortable minority, 30% of notaries said no, we have not yet used this possibility. We again find diversity among member states. In some member states, the percentage is much higher than 62%. So in some member states, almost all notaries have said, yes, we use the choice of law. In other member states, the choice of law is maybe less popular, but the general result is clear. Even though the choice of law was a novel instrument, and I must say for some member states it was a revolution, it's being used. And these results, these quantitative results, they also echo, they mirror what we've heard from our expert notaries. The expert notaries, for questionnaire number 2, we also asked them what their experience was, and remember the list of elements which expert notaries found to be positive. The choice of law was there. They even unanimously answered that the choice of law is a positive development. So here we can say it works. It works. The choice of law is being used. It's not enough. We need to go further, certainly. And one of the questions which is on the table is, it works, but is it sufficient? And many notaries commented on the choice of law by saying, yes, we use it, but we regret that it's so limited and that the client can only choose the law of his or her nationality. That's a question which is on the table. Should it be expanded, and should the choice of law also be made possible for other laws than the law of the nationality? And if yes, which one? Possibly, and this was a suggestion, possibly the law of the habitual residence. Turning to the law applicable if no choice of law has been made, which remains, I would say, the majority situation. And you know, in that case, the law applicable is that of the habitual residence of the deceased. We wanted to know whether what we have heard since 2012 at all conferences, during the coffee breaks, during question time, and that is always had the question, habitual residence, how does it work? How can I define it? How can I touch it? Is it not too difficult? The feedback everybody got at conferences and discussions was always, I have a difficult case, you know, this is really difficult. What do I do if this person lives in one country but has assets in another one? And if you look at the literature, look at the commentaries on habitual residence, it was at best mixed. Some commentators were very happy. Some commentators said this is horrible, it will never work, there's no legal certainty with the habitual residence. We wanted to know, is it true or not? Well, you can see here, you don't know the question. You see the answer, but you don't know the question. The question was, have you ever experienced difficulties in identifying the habitual residence of the deceased? And the majority says no. The majority says no. It's not an overwhelming majority. It's not 90%, but 62% is a very large majority. No, no difficulty in identifying the habitual residence. Granted, we have a situation where in some member states, more notaries had difficulties in identifying the habitual residence. Take Portugal. There, 60% of notaries have experienced difficulties in finding out what is the habitual residence. Certainly, we have to take into account the specific situation of some member states in terms of sociology and migration. We're all different. Portugal, I don't know what the current situation is in Portugal. The last I checked was there were many young people going to Portugal just to telework and you know, afterward going to the beach. But I don't think succession is high on their list of concerns, not yet. But by this I mean certainly the sociological and the migration phenomenon is different in all member states, and this may explain why in some member states we have more notaries saying it's difficult. What's I think more interesting is that when we asked our expert notaries about this, remember there were two stages. We asked widely all notaries, online survey, and we also had a open survey with expert notaries. Well, these expert notaries, what did they tell us? They also told us that they were also very positive on the application of the law of the habitual residence. For them, there was actually no major issue in the sense that, yes, a very large majority said it works. But both for questionnaire number 1 and questionnaire number 2, notaries told us there are residual cases which are difficult. There are cases which are more difficult. They may not be the majority, but these cases are difficult to solve. And again, I'm looking for the mouse, but it somehow disappeared. No, it's not this one. Where are you? You're not there. Oh, yes, there you are. Yes. What's also very interesting is that these residual hard cases, well, notaries agree on which cases are difficult. They agree on them. Which are the difficult cases? Well, difficult cases are when people move back and forth, you know. I would say a typical situation is that of a person who's maybe 60, 65, retires, is sick and tired of the climate in northern Netherlands or Belgium, where it rains a lot, and wants to spend more time in sunny Spain or sunny Italy, but keeps a place in his own country and moves back and forth. Another situation which is difficult is that of people who have recently moved. If you moved 2, 3, 4 months ago and settled in a new member state, is that an habitual residence? A situation which came back very often was that of a person working in one member state, but the family is in another member state. I think, looking at the situation of Poland, I'm not sure about the Baltic countries, but Poland certainly, that's a major issue. And this was a question raised yesterday, so I checked. Notaries also told us that one difficult situation is a situation of people living in institutions or hospitals or residence for the elderly without having chosen to do so. So these are the hard cases that were brought to our attention. There are other cases. The question is then, how do we solve that? Should we try to find a definition for the habitual residence? And if yes, which one? And should it be a definition specifically for this regulation, or should we be very ambitious and try to find out a definition of habitual residence for all private international law regulation? Will member states ever accept that? Should we maybe be a little less ambitious and reopen the recitals? Recital number 23 and 24 provide some guidance on the habitual residence. Is it sufficient? Should we go further? Should we make reference to other cases? So it's an open question, but certainly this, let's say, downplays a little bit the myth that habitual residence is completely unworkable. Notaries can work with it, except in those hard cases. And for some notaries, you will come across a hard case once every 2 years. For some notaries, there will only be hard cases because you work in in an environment where indeed people move back and forth, or you're just next to the border. And so you have a lot of customers and clients coming, shopping across the two borders. So again, situations could be different here. Last item, the European Certificate of Succession. Does it work or not? Again, one of the innovations, possibility to issue this European certificate. I have to say this was a gamble by the legislature. A gamble because member states can still use their own national certificates. So is it being used? Yes. 44% of notaries which we surveyed, and we surveyed more than 2,000 notaries, have issued an ECS. So it's slightly less than the majority, but it's a very good result, I think. And again, we have differences. Some member states have had much better experience with the ECS. In some member states, more than 90% of the notaries have issued ECS. In other member states, the results are less, let's say, less convincing. We have 10 member states where 75% of notaries have not yet issued an ECS, or where it remains a minority. But in general, 44%, an average of 44% is, I think, very positive. What's also very positive is that we wanted to know, why is it that some notaries have not issued an ECS? And the reasons were diverse, but they were also very logic. Some notaries told us, I have not done so because I cannot do it, I'm not competent. That's a very good reason. It would have been difficult to issue an ECS if you do not have the competence. Think of the German notary. Other notaries said, well, there was no need for an ECS in my practice because I have never had a cross-border succession case where this was needed. These are very valid reasons. And the message here is a message of notaries do not reject the ECS. These notaries tell us, we have not issued it because there was no need or I was not competent. I don't dislike the ECS. There is, to be fair, a minority, let's say around 10% of notaries, which have indicated that they don't think the ECS is useful or that it's too complex. But that's a minority. What's a little bit troublesome is that 4% of notaries told us that they don't know what the ECS is. It's a very limited number, 4%, and we're only in 2022. Let's hope that in a couple of years, every notary will tell us that they know what the ECS is. I take comfort in the fact that only 4% of notaries do not know what the ECS is, while more than 50% or 40% of notaries do not know the European Directory of Notaries. So the ECS enjoys a better, let's say, is more well known than the European Directory of Notaries. Conclusion, the ECS is not yet an everyday phenomenon in all notarial offices, certainly not. But there are clear signs that the ECS is being accepted. It's being used as an alternative to national certificates. Now, it's being used, but how often do we have figures on that? These are the figures, maybe a couple of comments. These are figures, but they're not complete. You can see that we miss a lot of data. And it's striking. Actually, data is only available for 10 member states. So there's something we need to work on if you want to measure more precisely if the ECS has become a success, or whether there are still difficulties with ECS. We need to know a little bit more precisely how often it is being used. And in the member states where it's being used, we must confess that the ECS remains, let's say, quite exceptional. Look at Hungary, France, Portugal, Slovakia, Croatia, or Belgium. You have a couple of hundreds of ECS every year. And if you correlate that, well, ideally we should compare that to the number of cross-border succession cases. But we don't have that. We don't know how many succession cases are cross-border cases. What we know is how many national certificates are being issued. It's not a perfect match because you may issue a national certificate in a purely national succession. But it gives us an approximate estimate. We can correlate and we can see the ECS remains the exception. So lack of data, the ECS remains exceptional. The good news, at least for the Commission and I think for the regulation, is that the numbers are going up. The numbers are going up. You can see in every member state where we have data, the numbers are slowly rising. So what do we take out of this? Well, this confirms the diagnosis. There is ECS activity in the member states, but on a limited scale. The ECS has not suddenly become the instrument everybody issues and replacing entirely the national certificate, certainly not. Which means that notaries make choices. They make choice. When do I use ECS, when do I do not? And it's very interesting that we got answers on these choice. How do notaries make choice? Well, notaries are guided by different concerns. The first one is, would it work? If I issue a national certificate, will it work for my client, and would it help my client in another member state to get the registration of the bank account changed or the registration of the immovable changed? If the answer is yes, my national certificate works because the client wants to use it in a neighboring member state where they know their experience with my national certificate, then the national certificate will be preferred. But if there are signs that the national certificate will not work, not be recognized, then the ECS is preferred. Another indication we received was that notaries, let's say, sort out succession by looking at whether it's a simple case or a complex case. In complex cases, they go more often for ECS. Complex cases include cases where you have assets in different member states, or when you have an immovable, which is perceived as being more complex. Let me turn briefly, and I'm almost finished, by highlighting that we also have received very interesting feedbacks on actual practical difficulties on the work floor in your practice. And we have heard today about these difficulties. Copies, 6 months for the validity, that's too short. Everybody complains about this. The forms, it has been said from the start, they're quite complex. I think we can agree on that. The difficulty is how do we simplify them without losing the benefit of all that information. Access to land registers is a major issue. It's nice to note that let's say for a minority of member states, the ECS works and gives access directly to land registers, but in the majority of member states, it's not sufficient. The ECS as such is not sufficient. You need to complement the ECS with an additional document or additional information, mostly information relating to the real property, the real estate asset. Let me conclude briefly, again, by underlining that we offered, together with Britta Lürger and Pierre Calais, a first analysis of the main points, and which will be refined. This was a very nice exercise yesterday and today. I think the discussion which we had and we will have today will help us refine the analysis. And now we will also start formulating policy recommendations, which will be the final step for this project. Thank you very much for your attention.
Labai dėkojam profesoriui, iš tikrai.
Thank you, Professor, for such an insightful presentation. Are there any questions, ladies and gentlemen, now that you've heard the situation which appeared after receiving the answers to the questionnaires on the implementation of the succession regulation? The first question is from myself to Professor. Which results were most surprising to you? Were you expected one answer and received another, or quite a different answer from what you would have expected?
It's a subjective answer because I had my own, past with the regulation. Which was the most surprising result? I would say it's on the choice of law, frankly. Why? Well, because as I've said, I don't know about the situation in Lithuania, but before the regulation, there were maybe 2 or 3 member states where you could make a choice of law. So finding out, I forgot the exact number, I think it was more than 60% of notaries who told us, yes, we used it. I didn't expect such a large majority to say, not only do we know it exists, but we've used it. This was the question. Have you used the choice of law? 64, I think it's 64%. So that's a very high level, which I had not anticipated. And I think we can be satisfied because it means notaries have embraced the regulation, have said, oh, this may be interesting for my clients. I will use it when it's possible, because you can only choose the law of your nationality, and when it is useful.
Dėkui.
Thank you. Are there any more questions from the audience? If not, let's go for the lunch break, and the lunch will be served in the restaurant downstairs. We are expecting you back at 1:30 to continue the discussion and the exchange of experience.
Tai sveiki visi sugrįžę.
So good afternoon once again. It's nice to see you after the lunch break. I'm happy to see that so many are still with us today. So we are now going to continue sharing our experiences, how successful we are in applying the regulation in different member states. And I would like to invite Eva Potter, Estonian notary, and she'll be talking about the implementation of the European succession regulation in Estonia.
Hello to everybody. Thank you for inviting me. I must say for the beginning that for me it is impossible alone to say what is the Estonian notary's practice, because I'm only one notary in Estonia. And when I speak today, I can speak only based on my own personal experience and from the experiences that I have from the notaries who have shared it with me. So I don't know all the experiences. So if today something I don't say, then I apologize before my colleagues who hopefully are watching this seminar via internet today. So with the European succession regulation, notaries are the ones who are carrying out succession procedures in Estonia, and they are also issuing the European succession certificates. In Estonia, we did implement the European succession regulation by providing in the law that when notaries are settling succession, in any event, they must apply the jurisdiction rules of the succession regulation, unlike in Lithuania. And the reason why we did this was that when notaries are issuing succession certificates, European ones, they are in any event obliged to apply the jurisdiction rules, and we provided that also in internal cases, we do also apply the jurisdiction rules to make sure that the outcome of the notary's decision cannot be different. One wouldn't want to carry out the succession procedure, find out who are the heirs, and then when the person comes to say, I would like to have the European succession certificate, so that the notary wouldn't be obliged to say, sorry, I cannot give you that. And in the worst cases, maybe in another country, the result will be different. So it will be the notary's liability for making a mistake. So it helps, I think, to reduce the mistakes of a notary also when they apply always the jurisdiction clauses. Now, it is impossible, I think, to say how many cases we have, international succession cases. Me, myself, I believe there is not such thing as international succession. There are cases where we have cross-border dimension. Those are the cases where we have heirs, property, or the deceased living in different countries. In some cases, maybe if they are in different nationalities also, depending on the state involved. So in Estonia, when we settle the succession cases, we never know that it may turn out into a cross-border case, because the aim of the procedures is to find out only who are the heirs. The aim of the procedure is not find out what is the property belonging to an estate. So in every succession case, the notary is obliged to issue the national succession certificate, and we never know when it has been used in another country. We cannot be sure if it's used or not in another country. So the statistics on how much notaries can see the cross-border cases is also not covered. So we never know the numbers and figures on that. But I can just bring out the numbers of the succession cases or certificates that have been issued in past years. In 2021, it was 2,000 more or less it's 10,000 per year, from which we can see the number of European succession certificates which is a very, very low number. I believe that the reason is not that we don't have cases with cross-border effects, but the reason is that Article 59 of the European Succession Regulation works very well. According to Article 59, it obliges a member state to accept authentic instrument from another member state. But it does not provide, or the succession regulation does not provide, that the authentic instrument must be recognized if it's not the court's decision. The procedures, I think, for the authentic instruments for recognition are the national procedures. And I think that the fact that we have such a low number of European succession certificates proves that national certificates are also recognized in other member states in addition. So we don't need to have always the European succession certificate. But there are some problems with succession certificate. Sometimes we do get the information that people are demanded of producing the European succession certificates. As I said before, I'm only one notary in Estonia. Myself, I've had issued only one European succession certificate, but I have helped quite few notaries in issuing the certificate, sitting next to them and doing that together with them, just to see what are the fields of the certificate, etc. And from that practice, I already know that there were 4 European certificates issued only because the bank of another member state, it was Finland, did not accept the national certificate. In one case, it was the Latvian registry, business registry, where it was needed for registering the shares and the name of the heirs. And in one case, it was the German land registry who demanded the European succession certificate. I sometimes think myself that the authorities of the member states are suffering under the memory loss, which I put also into my slide, because for fact I know that we have had national certificates from other member states used in Estonia, for example, for the heirs to register their bank accounts on their name. And the Estonian certificates have been used, I know, a lot in Finland for registering the bank accounts on the name of the heirs. And now, since we have the European succession certificate, we say, what is the national one? So it's a little bit surprising for me that the authorities can even demand it. Nevertheless, that the regulation does not allow to demand it. When speaking of the European succession certificate, then as already have been mentioned by previous speakers as well, there are so many maybe questions related that we as notaries don't understand, depending on the country where we are. One notary asked me to say today that it's too long, too many unnecessary fields. I must agree. When we start filling the succession certificate, the first thing it asks, who is the applicant? Is there a difference who applies for it? We need to know who are the heirs. No matter who applies for the certificate, it doesn't matter at all. Then there are the translation concerns. The European succession certificate is founded on all the languages of the European Union, which means, like the Commission says, you are not allowed to translate it. So what do? I am Estonian national. I'm sorry, I don't speak Lithuanian. I issue it in Estonian. But then there is the Lithuanian land registry. I'm sorry you don't speak Estonian. It's not my problem. I use my national language. I issued it. And then it comes to Lithuania, and Lithuanian land register says, I'm sorry, I don't understand the content. Commission says you're not allowed to translate it. But where is it written? I haven't seen the provision myself. It's a practical problem for the heirs, actually, who are struggling with it. We do have at the EGN portal the dynamic forms. I hope that you all have seen them. Please go see EGN webpage, which myself and I have helped notaries to issue these succession certificates, European ones. I always use the dynamic form. That first original I will print out in Estonian, and then the certified copy in the language where it goes. But I think that we cannot blame the notaries who are not doing it, because they're not obliged, they don't have to do it. And then there is this question of validity. Certified copy valid only for 6 months. Again, back to Lithuania. A notary issued a European succession certificate in Estonia, which was sent to the Lithuanian land registry, who said that no, it has to be in Lithuania. And by the time they were arguing, obtaining the translation, the validity expired, and it started from the beginning. And my notary asked me, what do I do? I don't know what they have to do, because translation is not allowed. I myself recommend to notaries that when we are using the dynamic forms, that they are in Annex 4 and 5, there are fields that you have to write something, yeah? Mostly it's the ticking boxes, but there are some fields that you have to write. And I always recommend, if you can, please do it in English. Maybe then that helps the heirs to use it better. But if you don't know English, tough luck. And then the need to list the property, which you say in Lithuania, it must be there. According to Estonian law, as I started, there is no obligation of a notary to find out in the succession proceedings what is the estate, what is the property belonging to the state. It's not important. We don't put any properties into the succession certificates. And according to our law, we say, like in German law, that the heir inherits everything. So it really doesn't matter. Is it a car, real estate, whatever it is, bank account? How can I, as a notary, issuing the European succession certificate, know what are the numbers or other indications that I must show in the certificate so you in Lithuania would understand that I didn't make a mistake in referring to real estate? I don't know. I don't know anything about Lithuanian property law, for example, yeah? So I might make a mistake there also, providing wrong numbers for you. I think that in Estonia we have also, you are obliged to notify the land registry with respect to which land you are going to make the amendments, but we refer to the property in the application to the land registry, and we attach the certificate to it. So I know that there are other countries also where they say that it is important that you show the data about the property that is provided that is inherited. And the European Commission has said, please show it, because otherwise in some countries, they don't even find out the flat if there is no reference. But on the other hand, it's the internal problem of a country, I think. You should know what is your property in your country. So for me, it is questionable to show the property. I've had clients who are the 4 cases with the bank accounts in Finland. The heir comes to my office and says, I need the European succession certificate. Why? I need to take it to the bank in Finland. My question is, in the regulation it says that I'm allowed to issue the European succession certificate only if you prove that you need it and there is a property in another country. But then the client tells me, sorry, notary, it's a bank secrecy. They don't tell me anything. I don't know if there is a bank account, but I presume it is because he was working there. So what do? I just put into the certificate, in those 4 cases, I recommended to put that the heir inherits the entire property, including possible bank accounts in Finland. But I didn't verify that I'm allowed to issue it because there was no proof of existence of a property in another country. So that's why I say it's questionable. Why do I have to show the property if the heir inherits everything? But now I think it's more, in practice, more questions raised for me when I receive or issue the European succession certificates. The European succession certificates should be preferred over the national one because the effects of the European succession certificates are provided in the regulation. We all know what is the meaning of the document. With the national certificates, we don't know the meaning. So maybe there is the advantage of the European one. But the European succession certificate does not create any rights. It doesn't give you anything more than you have inherited. So it's only to prove what are your rights. In quite few countries I know that if we have several heirs, then they are entitled to dispose the property of the estate only jointly. If it's done by one of the heirs, the transaction will be void. But I have seen European succession certificates from such countries where there is absolutely no reference to any restrictions. So then it is my question, when I issue the certificate and I do not add into Annex 4 or Annex 5 that there are restrictions, for example, that one heir cannot dispose the property alone, who is liable? Is it the authority who issued the certificate, thanks to whom one heir went and disposed all the entire estate, left others with nothing? Or is it the responsibility of the receiving authority who knew that there is a mistake? The Article 69 of the European Succession Regulation says that the regulation produces effects it shows, and it is presumed that there are no additional restrictions if they are not provided in the certificate itself. So who is responsible? Please, notaries. Make always sure that you provide all the restrictions. I have recommended to the Estonian notaries always to indicate the joint right of disposition, as well as, for example, that if the heir is the minor child, the obligation to get permission from the court for the disposition. It depends, of course, from the habitual residence of the child. But those types of restrictions, I think, should be always shown in the succession certificate. And then I would also like to speak about Annex 5, and I'm very sad that Stefan left. It's the annex about the legacy, the legatees. And I also, as you can see, have indicated to Kubitschka case that also did he. In the Kubitschka case, we found out that there are 2 types of legacies that can be made. One of them being the direct right to claim the ownership of the property, and the other one, the right of the legatee to claim from the heirs the ownership of the property. And in this case, the ECJ, I checked it out during Stefan's presentation, the ECJ stated in point 49 of the decision that the legacy of indication and legacy of damnation is the method of transfer of ownership of an asset, and vindication concerns the arrangement by which the right is transferred at the time of the testator's death. Article 63 of the European Succession Regulation says that the aim of the heir or legatee, they can invoke their rights in another member state based on the European succession certificate. And this is why I think that in any case, the legatees would need also the European succession certificate. In Estonia, we also have the damnation principle, where the legatee only has the right to claim the ownership of the property from the heirs. But if they need to go to another country to enforce their right to claim something from the heirs, to make sure that the heirs do not dispose the property without giving it to the legatees by the will, then they do need the European succession certificate. And in Annex 5, about the legacies, is also the point on restrictions. And I think this is the point, at least I have advised the notaries in Estonia, maybe I'm doing a mistake, I don't know, to provide in the certificate that it's only a right of claim against the heirs, but then it should be issued together with Annex 4 showing who are the heirs from against whom you can submit that claim. So my interpretation of Article 63 and the Kubitschka case is completely different, what Stefan said. So maybe Lithuanian court will take it to the ECJ, please. Yeah, but they are welcome. I mean, none from Estonia yet, but we know what we are doing, hey. So, double proceedings, something that we spoke before. When I speak of double proceedings, I don't think only court proceedings. I think also those cases where notaries are settling the succession. I think that my obligation as a notary by Estonian law is to make sure that people would avoid any legal disputes, unnecessary costs. I have to protect their rights. I feel that it is my obligation to explain to my clients that, hey, we have those jurisdiction provisions here, that maybe in other countries they don't look at them, notaries don't apply them, but your right is to turn only actually to one country and get the succession certificate from there, and based on that, to register the name on the heirs. So you don't have to do in different countries. I myself had a case where the deceased was living, dying in Estonia, had property in UK, he was UK national, and Italy. They first started with the case in UK, which they anyway should have done. Then they went to Italy, and then they came to Estonia. And I'm like, but why didn't you come straight away to Estonia instead of going to Italy first? Last week I heard a case of a notary where proceedings were initiated in Estonia, in Austria, but there is also property in France and Poland. That will be exciting, huh? I did provide to that person a detailed explanation what they should do. But sometimes I have the feeling that, is it really that important to settle all the cases of entire property in your country? Or should you sometimes consider the interest of the heir? It's expensive. It's very expensive to have several procedures in all different countries. Notaries get profit. I think it's not good for our reputation. Then I think that those double proceedings, the best solution, one thing is that we would explain to people, to explain what their rights are, but the other thing is the jurisdiction provisions. I can't understand why can't notaries apply jurisdiction provisions. I think it's a loophole in the succession regulation. Notaries do apply jurisdiction provisions, for example, for cases of divorces or parental responsibility based on Brussels II regulation, and they handle it very well. But it seems like with the succession cases, they should say, I don't know even the meaning of the word. I mean, I think that this regulation should be amended in a way that all the authorities must apply the jurisdiction provisions, and we would have much more less disputes. And then I've had my last point, and I finish. I've had clients where the deceased has died in another country, or the family main assets, real estate, is located in Estonia, and there is no will. So the heirs are put into the situation that they must travel to another country to settle the succession there, to the country where they've never been, maybe. And that is also very, very cumbersome for them. Yes, we do have provisions in the regulations saying that if there is a will and the choice of national law, then the heirs are allowed to choose that the case will be settled in a country of the applicable law, which is a very good possibility, I think. But in practice, maybe it hasn't worked yet because the procedure is too young. Those wills are not enforceable yet. They have not died yet, so maybe it will come in the future. But I think that also for cases where all the heirs are living in one country and the deceased only living in another country, it should be the possibility for the heirs to change the jurisdiction to that country where they reside. For notaries, it would be very bad, because that would mean that we would have to apply the foreign law. So which way we go? But that is my experience. Thank you.
Thank you. Tai dėkojame Evi ir kviečiam.
We thank our colleague and we give the floor to Aigar Skaupe, Latvian notary, member of the board of Latvian Sworn Notaries Council.
Dear colleagues, what a pleasure it is to be here again in Vilnius. Not my first time, and I'm really enjoyed to be here. Thank you everyone who is involved in organization of this wonderful seminar, Marius, Laima, Egle, Sima, and all the others. You always make us feel like home, very friendly and warm, welcoming atmosphere. I would like to deal with you with experiences Latvian notaries have seen as advances of application of the European succession regulation. And I will focus on four, that's my name, you can see it. And I will focus on four issues. What we figured out would be point of interest of also other colleagues to hear. The one is about sworn notaries' obligation to follow judgment and findings of Latvian Constitutional Court towards respect of the rights of the same-sex couples. Also about the right of a child who is born to a surrogate mother. And then about status and choice of applicable law if the person has no any citizenship, but the person is having a specific status of non-citizen of Latvia. I will tell about it later. Some countries might know that status, but many countries, or most of the countries, shouldn't know. And then the fourth would be about issues that notaries face when they have to obtain information from foreign banks about assets being left in the foreign country. We have spoke about it already, but maybe some advice would be helpful also from Latvian part. Yeah, so the first item I want to speak is about what has changed during last years in Latvia. The law didn't change. The law did not recognize, the civil law Latvia does not recognize neither same-sex couple marriages nor partnerships, and this was like hot potato in discussions of politicians. Also, in several cases, there were already drafts being looked through in the parliament, but they never went down to the final decision of the parliament. And it happened during last 2 years that there were two cases initiated in the Constitutional Court about the rights of the same-sex couples, and these decisions or judgments of the court came into force 1st of July this year. And what is the difference from what was before and what is now? The first glance, maybe you think, what is the role of the notary? Yes, first of all, judgments of Constitutional Court are obligatory, compulsory to everyone, to every institution, every court, also notaries as a profession, also every person. So it comes also as an obligation of the notary to apply correctly judgments and statements being made in the Constitutional Court's judgment. What did they say? They say that first of all, a legislator has a positive obligation which arise from the first sentence of Article 110 of Constitution of Latvia to ensure legal, social, and economic protection of every family. It doesn't matter whether the family is of different gender or the same sex. And that human dignity must be respected in all these cases equally. So it means that, first of all, the legislator is obliged to establish legal framework for protection of the same-sex partners. It also set the final date until which it has to be done, and the date was 1st of July 2022. This is the date when the judgment comes into full force. The parliament, unfortunately, didn't make it in timely manner, mostly because elections were expected on the 1st of October, which took place just recently. And these parties arguing, they said, okay, then maybe this is what the new elected parliament would be considered. At the moment, the draft of the law for the civil union partnerships is on the table on the parliament. 2 readings has been successfully passed, and now it waits for the 3rd final reading yet to be adopted. But until notaries are waiting whether or not the new law will be issued, we already have some obligations because the Constitutional Court's judgment is into force, so we cannot ignore it. And it means that if the spouse of the same gender who have concluded the marriage or have concluded partnership agreement in another country where it's allowed, then the notary should accept the application of that surviving spouse in the succession case, because these rights, as the court said, have to be treated equally. Also, notaries are really waiting for the new law because it will allow notaries to become the competent authority who conclude these agreements of civil union and also terminate them. Yeah, that's the first what I wanted to speak about, and now we will go to other case, the other issue. This maybe does not reflect that so directly the notary's practice, but the problem still exists, and it's all around the succession, and especially international succession. In many countries, there is surrogacy allowed, like when the mother cannot have a child, they might find a surrogate mother who will carry on the duties of the carrying the child, and then give the birth to a child. So then there are like two mothers. One is biological one, and then the other one is the legal one or intended one. And this interaction of those people, two mothers and the child, there are several interests, of course, and in the countries where there is not legal framework being established about how to regulate these relationship and these rights, then in those countries, well, we are just lacking the regulation, and it may bring some problems. I can't say that it's not possible to resolve these actually existing relationships between two mothers and the child by other means. Yeah, it is possible. The mother who gave a birth can abandon the child, but it has some certain time period when she cannot. It's more than half a year, I believe, in Latvian legislation. Then the other process have to be established, like adoption process, which also takes another time. But what will happen with the child during this process when the child is born and when the legal mother or the intended mother is proved to become a mother or of the adopted child? Yeah, so if the child passes away, then that he cannot inherit from her legal or intended mother, because only the mother which is entered into the birth certificate will be considered the mother by a Latvian notary. Yeah, so this problem should be tackled, it should be resolved. At the moment, on European level, there is no regulation, there is no obligation to every country to establish such certain legal framework for surrogacy. So it's the state's choice, but we have had two court judgments. European Court of Human Rights had two cases looked through. You can see the names of these: Manesson versus France and SH versus Austria, which already states that the child's best interests prevail and the state's freedom to choose whether or not to tackle these problems is also limited. State is obliged to guarantee person's identity, right of private life, and also guarantee child's best interests. And if these cases are not regulated, then the problem is created to the people who produce that process, or who go through that surrogation process. Yeah, thank you for that. Maybe some other colleagues, if there are colleagues from different countries presented, if you later on think you know anything that you could add to my I would say question, because I don't give any answers. What would be good practice, how to organize the rights, and what would be the legal framework for guaranteeing the child who is born in the process of surrogacy. But this is definitely the question which will come into the notice of the notaries, I think, in near future, because even if I don't have particular statistics about it, we know that these elements are being in use more and more widely. Then I would like to go to the third item of my presentation, and this is about a specific status of some certain amount of residents of Latvia. I know that Estonians had them plenty as well years ago, but you managed to resolve this issue transferring this status to other status. I believe it was the case. I heard about it, but in Latvia, legislator didn't anything. So, who are these specific people I'm talking about? These are people who are neither Latvian citizens. They are neither citizens of any other European Union country. They are even neither citizens of any country, and they are also not refugees. They are those who have born in Latvia, but they, due to the collapse of Soviet Union, and also after some time after that, they born in Latvia, and they didn't gain the status just because their parents or they never been the Latvian citizens, and they didn't qualify to become Latvian citizens automatically. At the moment, like 3 years from now, those newborn child, they are automatically guaranteed the Latvian citizenship. But for the period until that, that guarantee didn't exist. So it's about 300, we speak about 300,000 people who have that status in Latvia. What do the Ministry of Foreign Affairs define? What are they? They say they are non-citizens of Latvia are considered to be citizens of the third country. Even so, they don't have that citizenship of any third country. But this is more from political point of view. They don't have rights to vote, they don't have rights to go to the army, they don't have rights to hold important positions in the state or the court. For instance, they cannot become notaries nor judges. But if it comes down to the civil rights, then they have all the same rights as Latvian citizens or European Union citizens. For instance, there is a limit there is a limit that not every land can be obtained into the property of any person. For instance, agricultural land in Latvia can be obtained only by citizens of European Union. Third country citizens, they are not allowed to obtain agricultural land. But in the law, it's prescribed that Latvian non-citizens are equal to citizens, so that they can obtain the land. And the question rises now, what about rights, which are also civil rights of the non-citizen? Would non-citizen of Latvia would be able to choose applicable law in the testament, in the last will it drafts? From deferring these political rights and civil rights locally in Latvia, I would say rather the content of the rights say that they are equal to Latvian citizens, and if Latvian citizens can choose citizenship between the last place of residence and the citizenship country, then they should be allowed as well. Yet we have to take into account that local legislation is a little bit lower in the hierarchy, so European regulation is higher. And European regulation of succession says that only the country, the applicable law of the country of citizenship can be chosen in the last will. So if you don't have that citizenship, then you can't choose the applicable law of the country where you are non-citizen. From grammatical point of view, they wouldn't. but from, I would say, when you feel the essence or limits of non-citizenship rights, then I would look further that they would be needed to be able to choose. Again, should European Commission to do something, or the European Parliament do something about it in order to amend succession regulation? I don't think so, because this specific element, like non-citizenship, exists not in every European Union country, and maybe only few are left. Maybe it's not a tragedy if they don't have that choice. They still have another choice. They can become citizens, and then they can choose also the applicable legislation. That's my opinion, but yeah, but the question of course exists, and yeah, in disputes maybe non-citizens at some point could go to the court about denial of their rights to choose the applicable law of Latvia. And the last question I would like to speak about is the one we have spoken already today several times. It's really an issue, we can say, since almost everyone who spoke today spoke about it, that the banks who give that the banks don't give a proper information to notaries in the succession cases. But I cannot say that it's a tragedy, and I cannot say that it's always like that. Now we have also good experiences. For instance, me particularly, I had a succession case where the architect who have been working in Germany left assets in 2 banks, but then when he retired, he moved to Latvia because he was Latvian origin. And he died in Latvia, so the case was here, Latvian law was applicable, but the assets were in the 2 banks in Germany. So very simple thing, I just wrote a simple letter that I am the notary, I'm performing the succession case according to Latvian legislation, and for that purposes I need the information whether or not the client was your client, the person was your client, whether or not the person had bank accounts, and if so, what assets are there. So the bank, one of these 2 banks in Germany responded very swift, like in less than 2 weeks' time. The other one, we were waiting a long time for the answer. Finally, they gave an answer that they, due to the confidentiality principle, they cannot deal with that information. Yeah, so one country, 2 different banks, 2 different attitude or understanding of the successions regulation. We all have also issued, I'm also, you maybe saw and noticed at the beginning, I'm also the member of the Chamber of the Latvian Notaries, and can I tell you that we issued recommendations for our notaries how to act in these cases. If you have found that there is asset in some foreign bank, first of all, write the simple letter, but in this simple letter, please not make the bank to figure out whether or not are you authority who performs succession in Latvia, and that our European succession regulation applies to you. So give that information already in the letter. That based on Latvian notariat law, you are the authority who produces these cases, and then based on the successions regulations, you are authorized to require that information from the banks. Probably it will be less likely the banks will deny to give you that information. And if they still deny, then fill up that long form of 34, I don't know how many pages. Of course, it's time consuming, it's not effective, it shouldn't be done like that in every case when you need the information to obtained from the bank to fill up the long form. But if that remains the only option, how you can get the information needed, then do it. And then use the succession certificate as the tool just to obtain the information from the bank. We luckily in Latvia didn't have yet any claims in a court against actions of the notary. In succession certificates, I would say it's already a significant amount of succession certificates being issued in Latvia. When we met for the first European Commission's organized seminar in Tallinn years ago, that was just the start of application of European Union's new regulation. At that time, we only had 2 cases, I remember. So we were speaking about the application of the succession regulation very theoretically. But nowadays, I would say we have some practice, and now we gain some muscles. I would say that the actions we take probably were not wrong. And the overall, the succession regulation is quite good success and very useful for clients, and also useful and comfortable for notaries. Yet it can be proved, of course. We just spoke about these aspects where it should be improved. And at the end, let me conclude that notaries in Latvia, and I would say that that would be the case in any other member state. Of course, we cannot exclusively rely only on local legal acts. Some countries said that they are not entitled to use legislation of other country, and some say you are entitled. Due to the Latvian notariate law, we are entitled. And of course, it has to be learned what the legislation of the other countries say about the particular case which is in the notaries, which is on the notary's table. So we really have to open our mind, be ready to learn. Not theoretically, I think, more practically from case by case. And notaries always have to bear in mind and follow findings and statements of European level courts. For instance, we noticed the European Court of Human Rights mentioned here today in my presentation. Also, especially judgments being made by Constitutional Court, because they are compulsory to the notaries immediately. And notaries also, of course, need always to train their skills to correctly ensure persons' rights and take into account these international aspects in all succession cases where the international aspect comes as the part of the case. And overall, I wish all notaries a joy in our daily work. Then it makes more easy to resolve problems, even if we face them. And of course, natural urge to learn. And thank you for listening me up today. And if you have some questions, you can also ask them right now. But if they raise up later, please refer personally. That's my email here. Thank you very much.
Thank you, Aigar. Dėkojame Latvijos atstovui.
Thank you, our colleague Latvian notary. And now we'll be listening to the Polish experiences with the implementation of the European Succession Regulation. And the floor goes to Tomasz Scott, Vice President of the Polish National Notaries Council.
We are late, yes, I suppose, or not? Not a problem. Okay, thank you very much. Firstly, I'd like shortly Thank you to you for this invitation, and I would like also congratulate to you to choose the Vilnius as a place for this conference, because in speaking about European regulation of succession, we talk especially about transborder problem between Germany, between France, Germany, Luxembourg, Belgium, etc. But we are in the situation that our both countries, I mean Poland and Lithuania, we are in 500 years with unity, with common border. So the transborder problems with succession, it's our it's very well known in our by our lawyers and our practitioners. Also the problem, we can say, multi-citizenship, because our kings at your ground dig, it always in the same time it's a Polish and Lithuanian citizenship. But it's a we can say point of start for us. I'm passionate about history, so I would like to start with this my presentation from other point of view. What European regulation changed in our law? What it was the state of play of the moment of the entry this European regulation, and according to According to Code of Polish Procedure, Polish court has national jurisdiction inheritance cases in case decided person had at the time of the deed was a Polish citizen or had his place of residence or habitual residence in the Republic of Poland. I'd like to stress habitual residence because the Polish rules of jurisdiction was changed before European regulation using this factor habitual residence, and national jurisdiction also included inheritance matters if the inheritance property or significant part of is located in the Republic of Poland. And national jurisdiction in cases, also in succession cases, was exclusive for Polish court in case if this decision concerns rights in a real estate or possession of real estate located on the Republic of Poland. So it means that before this European regulation, every cases of succession when the intertaxation constitutes real property in Poland must be passed by Polish court. This is the first question. And according to Polish private international law, starting from 2011, the testator in a will or other disposition in the event of death may submit the inheritance case to his national law. It was choice of law, and the law of his place of residence or the law of his habitual residence at the time of performing this act or the time of his death. In the absence of choice of law in the succession, the law of the testator's home law at the time of his death shall apply. So, saying fairly, these rules was in force only 4 years, because we have new private internationals from 2011, but before we had private international law 1965 that it was connector factor only citizenship before this was tradition. But the tradition is in Poland that we have always unity of succession. And I would like say something we can say special, something special about the Polish situation, because we have about 20 bilateral contracts, and with couple of them is with provision about private international law in matter of succession, and a couple only on question of jurisdiction and the court procedure. And I would like, I would like mention that before we had with this convention with Czech and Slovakia, with Croatia and Slovenia, with Lithuania, Latvia, and Romania. But no, this provision about these provisions about private international law in matter of succession, it doesn't work between us. But it was the before it was in vigor, and now we have convention with Belarus, Bosnia, Herzegovina, Montenegro, Serbia, Macedonia, North Korea, yeah, Libya, Mongolia, Ukraine. It's very, we have some problems with this convention. Vietnam, and we have also this bilateral convention with China, Egypt, Iraq, Morocco, Tunisia, and Turkey. But it's a question about the court procedure, about the jury, not private international, not provision about the private international law. Why I would like to say some couple words about this convention, because in this convention I use the convention with Lithuania just as a model, because in this convention we have split. So, it means the succession about immovable property are governed by the res sitte, and other question it's governed by the law designed by citizenship. And also the jurisdiction also is split. So it means the court res sitte is can deal with this case, and we have in this moment we have all the problem, especially with Belarus, Russia, and Ukraine, because, for example, with the Ukraine citizen in Poland, we cannot deal with question. The notary cannot deal with question with succession, because Polish law doesn't expressly give us a possibility to make partially this declaration of succession. So it's a practical problem. And I would like also says one thing. Before the European reglement, Polish notary could only deal with the succession cases so-called internal. I mean that it decided person was a Polish citizen in succession. It's only located in Poland, so that it means without immovable property abroad. it was our limitation. Other cases, it could pass only by, it could be dealt by the court. And on the moment when the European succession regulation was became in the force, Polish government changed our internal regulation and make, for example, for us wider scope of succession cases. So now we can deal with international succession. We can say, and why? Because Polish notary are bound by jurisdiction rules. We are not a court, but we are bound by provision of notarial law in Poland by the jurisdiction rules. It means that each Polish notary dealt with succession must know European regulation, because we should establish Polish jurisdiction. And in my opinion, a notary public in Poland is entitled to draw up an inheritance certificate if he is able to establish that very national jurisdiction is in a given case and to determine the law applicable to the inheritance case. And of course, to define the content of this law. This means that the notary public should establish circumstances affecting Polish jurisdiction and the jurisdiction over a given law. Therefore, if the national jurisdiction or jurisdiction would be based on ground other than the nationality of the testator or the place of habitual residence of the testator at the time of his death, which let the notary public determines on the basis of the person concerned, the notary should establish these other circumstances that provide appropriate explanation in the inheritance report together with specification of the evidence. This is also the problem in Poland, because in our internal notarial law, for facilitate the situation of the notary, it stipulates that notary obtain only declaration of the parties that jurisdiction is Polish. The last plate of on the moment of the death of the person was in East Poland. It's only a declaration, but in practice we try to verify this declaration to avoid the problem with with plural procedure. And I'd like to say I'm representing the past, and I'd like to introduce in this moment my young colleague Viktor Karpowicz, who is notary in Warsaw, he has our video, and he presents us the practical problem with application of this reglement. Thank you.
Labadiena, hello, dear professor, dear colleagues. I will share some of my experience from my last years of practice with Regulation 650 2012. I'll start with the jurisdiction matters. As it was said, Polish notary, just like I guess Estonian notary, and unlike Lithuanian notary, is bound by jurisdiction rules, led out an European regulation, because it's stipulated in our Polish notarial law. So a notary is prohibited to issue even a domestic certificate of succession in Poland if there is no jurisdiction. And as Poland, we are a society of high mobility, very migratory. It's often very difficult to determine the place of last habitual residence, especially taking into consideration recitals 25 and 24 of the regulations, because as you know, there are two vague concepts that may reiterate the whole case to different grounds. So manifestly closer connection. There is an article saying that the law applicable in the absence of choice of law is not actually always law of last habitual residence, but we must primarily look if there is a country of manifestly closer connection. And in case of Polish citizens who emigrate a lot and then come back or frequently visit Poland for different purposes, it's very difficult to assess whether the Poland or some country in the west of Europe was the firstly place of last habitual residence. Secondly, even if a different country was a place of last habitual residence, then maybe still Polish law would be applicable or another law would be applicable because of this manifestly closer connection. And if we decide, if we assess that another law is applicable because of this manifestly closer connection link, then it affects substantially the financial situation of a hearse, right? Because we all know that different laws provide for different order of succession, and that is a problem of many notaries who are well aware and well acquainted with succession regulation, because I assume that this manifestly closer connection is not a provision that every judge pays attention to in his daily routine, but yeah, but something that is a challenge for us in this highly migratory society like in Poland. And secondly, we have these bilateral agreements, mainly, most prominently with Ukraine, also with Russia, Belarus, and Vietnam. These are most frequent cases when I have problems because we have a split jurisdiction. So partly we have jurisdiction as to immovable property, but also we have a possibility of forum shopping because, for example, Germany, France, Belgium are not bound by bilateral agreements. The main connecting factors with applicable law under bilateral agreements are law of nationality and frequently as to the immovable property lex situs, so law where the property is located. So an example, Ukrainian citizen, last habitual residence in Germany. If a German court is settling a succession case, German court will apply German law as last place of habitual residence to the whole succession, whole property. Polish notary also retains jurisdiction, but as per bilateral agreement Poland-Ukraine, but will apply partially Polish law as to immovable property located in Poland, and in some cases, well, all the property is located in Poland, he will apply Ukrainian law as to movables. Usually Polish notary doesn't have jurisdiction in this case, but in special cases, there is a room that there is jurisdiction in Poland as to the whole case when all the property was located in Poland, not in Ukraine. And then Germany would apply German law, Poland would apply partly Ukrainian law, partly Polish law. And the outcome would be totally different, as we just learned that in Ukraine, parents may come in the first order in conjunction with children, right? That was something I learned a couple of days ago only. So now some other remarks from issuing authority and receiving authority, I may say. In Poland, we do not pay a lot attention to division of assets, or sharing out of estate as it is written in the regulation. So the main aim of succession proceedings in Poland is to establish who is the heir, in which parts, in which shares. And most of the cases do not end with division of assets. And in this case, when we receive European Certificate of Succession, or when we receive another authentic instrument from abroad, which doesn't, in case of plurality of heirs, and this document doesn't specify the shares of the heirs, this document will be perceived incomplete. Like it can be the case from Finland, Sweden, Germany, Austria, when we just received information that the heirs are A, B, and C, but without shares specified, because it's indivisible, or the practice says that we do not specify the shares because they are provided in the law. So in this case, there is a high degree of possibility that the land register court will reject the submission and will not record the property. Finally, we have a big problem with cross-border waiver of succession. There are many cases. In my not long experience, I have a very large amount of people living in Poland who would like to submit the declaration on waiver of succession after someone who died resident in Western Europe, like in Germany. Because in Germany, we have a default rule that if you do not waive the succession and you do not declare whether you accept or reject, then you accept with unlimited liability. In Poland, the default rule is the liability is restricted. But in Germany, for example, not. And there are many cases when clients come and they would like to make availability of Article 13, make benefit of this provision. Okay, now I adhere to Polish form, to the form of the country of the place of residence. In Polish case, it would be signature, just authenticated signature, but in practice it's not enough. That mechanism doesn't work, and I would say observations and conclusions of both Courts of Justice and Attorney General in case 617/20 TNNN could be very useful for future legislation, but present observations of Court and Attorney General can be also very burdensome for notaries, because it may be implied that the notary is obliged to transmit translated declaration on waiver to the authority that has jurisdiction under Article 4, right? And that is something that is not directly stipulated in the regulation. That is not our obligation. And then clients come and expect us to do it. So my view is that some more clear provisions should be elaborated as to formal requirements, deadlines, and communications between the receiving authority, ex Article 13, with the authority that has overall jurisdiction. And finally, I just may say this as to title property, registering title to property. That is something that is most flagrant, that is interesting, everyone here. Poland is a country like Estonia. We do not mention we do not itemize what is included in the estate. We also would be very grateful if Registru Centra's case would have an outcome like putting a big weight on effet utile, right? So that's just my view, also view of my colleagues, I guess. Thank you for your attention. Didžioji ačiū.
Ačiū labai abiem Lenkijos atstovams už.
Thank you so much, representatives from Poland, for your history, for your presentation of the past, present, and future. And I give the floor to representative from the Dutch Chamber of Notaries.
Okay. Next. My name is Sabine Heining. I will speak in English to you, if you won't mind. I have been no, come on. Why is it not working? That's easier. Yeah, that one is easier. Okay. I've been working in the chambers from 1990, and at that time we wrote very extensive reports about what law would apply. Pages and pages, really. So the private international law, to what can you go to a notary, or do you have to go to a court? Who are the heirs, etc., etc. I think nobody really read this report, and it made the life of citizens very difficult. So I think we should be very happy with the succession regulation, because now we have rules that one law applies in all member states. So that's something we should never go back to, because it was quite complicated. The present. I will share a few experiences. In the Netherlands, the choice of law was part of templates, models for many years. So we have quite a lot of old choices of law. And another fact is that the Netherlands was the only country who applied the Hague Convention. And we had a choice of law in Article 5 of the Convention, not only for the national law, but also for the law of the habitual residence. And it worked fine. I will come back later to that. We have quite a lot of cases with Article 34, the renvoi rule in the Netherlands, because we have a lot of people coming from the UK, owning real estate in the Netherlands, going back, a lot of people from America. And I don't think that citizens and notaries really understand these rules. It makes life quite complicated, although I can resolve them, it's my work, it's fine with me, but it's complicated. So, you know, the renvoi rules are normally not in European regulations, and here in the succession regulations we have it. And it's not easy, but we can work with it. But let's say we have quite a lot of cases. So it's my experience. The differences between courts and notaries, that's also something not to, I don't think that people understand that. We start in the beginning and we thought, okay, in which cases we will issue an ECS. I wrote for the chambers a kind of handout how to fill in the ECS to help them. And in the beginning we said, okay, we have a new instrument, we use it for the international cases. But then came Oberle, okay, and we said, yeah, but we are notaries, and in the Netherlands the notary issues the national certificate and the ECS. So we are not courts, so Oberle is not for us. Then we had the WB case and we had EE again, and I said, okay, so we notaries, we are free to follow the rules. If we issue the ECS, then we are bound to the rules of the regulation, and if we just issue the national certificate, we are not. I don't think that people understand it, and neither do notaries. And I heard Eve saying this, and I can support her in this, and said, it is difficult to find your ways. And what I see, for example, and I do oppose to this, I had conferences with French notaries, and they were so happy with this outcome because they said, you know, before 2015, we issued only national certificates, and in the cases with inheritance cases with France and the Netherlands, they said, oh, we go back to the old system. So if the Dutch citizen owned real estate in France, they said, can you please issue a national certificate? We know how it looks, and we issue a national certificate in France. So you have two, and nobody spoke about the ECS then anymore. The heirs do not know this, and they will make extra costs, I think, and it's a burden. It's not good, and that's what you said as well. So I do not understand it. And there is a difference. between the ECS and the national inheritance, although in the Netherlands is quite, we do accept the internal national certificates in international cases. We do. And even the public register does accept the national certificates. But there is a difference and it makes it complicated. So I think the rules now in the succession regulations should be more strict. It makes life easier. Another thing we noticed, that as we have a lot of choice of law cases already in last wills for years and years, so we have quite a lot of cases, and the choice of forum, all heirs have to accept it, and then you can change. Article 4 is then not applicable, so you may be, let's say, for example, a Dutch citizen living in Italy, but he made a last will with a choice of law in it, but then all the heirs have to accept it, and if they don't do that, then there is a problem. And that happens quite often. We have quite a lot of divorces, so there are children from first marriage and then a new wife or new husband, and not always do they go along so smoothly. And if just one child says, sorry, I don't sign, and then we have a problem. And it happens quite often, and the whole winding down of the estate is stopped, and it's a problem, really. So, I think that's... another issue is finding lost wills. I think we should be very happy with the alert and with the people who are working for it so hard. Thank you, Celine. It's maybe your last time we see you here. Yeah, okay. That's good, but we have still some countries who are not that willing to give information about last wills, although they joined the alert system. But I know for Germany now, there is a way now, you have to fill in a form and then you get the information. But I'm sorry that Stefan already left, because Austria, you must send an email to the court, in one court in Vienna. And so far as I am informed, this court only wants to give information that there is a last will in Austria to other courts and not to notaries. So there are still problems to overcome here. We had recently the waiver of succession. We had this case where the Dutch heirs were involved. I don't know if you know this case. It was from June this year, so I only gave you the C number. There are some interesting things, because you can really see, and it's about waiver of succession, how things can go wrong. Because this was a simple case. It was a German man who he was Dutch. He lived in Germany. He had made no last will. He left a wife and no children. And according to German law, which was applicable, there were two nephews who also were heirs, and they didn't want to be heirs. So they wanted to waiver and they wanted to resign. We have the possibility that you can go to another court because the nephews lived in the Netherlands, not in Germany, so they went to the Dutch court. But then things completely went wrong. So because we have this 6 months period according to German law, within this period you have to waiver the succession. And they did the right thing in the Netherlands, but the German court did not accept that. And one of the things was that they sent letters in Dutch to a German court. And the German court said, sorry, can't read it. And they didn't do anything with it. And then now the procedure started, and we have now a lovely, beautiful decision of the European Court. And they didn't mention anything about translations, but they didn't say that, but they said, sorry, a German court, you have to accept according to Article 13 and the form, if it's correct according to the form regulations in the Netherlands, you have to accept the waiver. So shut up with all this nonsense about languages. So be careful if you receive, also for a notary, a letter in a foreign language. You cannot say, I can't read Greek, I can't read Estonian, please use Google Translate and find out. Maybe if the one who's sending the letter, and you can ask for a translation, but you cannot, they're not obliged to do that, so yeah, so we should be, my conclusion is we should be a little bit more cooperative, more lean, find ways. For example, we have now this conclusion, it's about Lithuania? No, it's a Lithuanian case, yeah. And I'm quite sure that the outcome will be Lithuania, shut up. You have to accept, yeah, it's true. You have to accept the German, because the German certificate. And German law has what I call the Sezin, so you don't have to mention all the assets. And in the Netherlands it's the same. You don't have to mention the assets in the ECS. And even you can't, what was mentioned for you by the bank accounts, banks will not inform you about accounts, foreign banks, but even not in the Netherlands. If the bank is nice to the notary, he said, yes, there is an account, but he will never mention how many credits there are, how much money is on the account. Will never tell you. You must first see a national certificate or an ECS. So, my wishes for the future. I really would like a choice of law for the habitual residents. We have quite a lot of cases where there's a husband and a wife. The husband, for example, is Dutch and the wife is now fill-in. Wife cannot choose for Dutch law, so they cannot make the same last wills in the same way. Although you can say, we make a last will, and as long as the wife dies and has habitual residence in the Netherlands, it will work. But you cannot assure that. And I will not go in discussions of the reserved shares, and but I find this difficult. And there's also, you know, this French article, what is it, 913, paragraph 3. This is a shame, really, that they introduced it, because it has nothing to do with international law rules and regulations. So I'm not really feeling comfortable with it, and it's a burden for Dutch citizens who have connection with France. And although we have a reserved share, but we cannot affirm, no, there are no problems with France, and you cannot have any, so that heirs have a point of, so they can ask for the extra help of this new article. I'm not quite sure, and nobody will tell me. So I'm not sure what to do with it, and I'm not feeling comfortable with that, but okay. And another wish, so the choice of law, I would like to have more possibility to choose for the habitual residents. We also, in the Hague Convention, we had already this option. No problems we ever had with that, and it was quite okay. The choice of forum, it would help if we have still one heir who is not willing to sign. The example I gave, it is a burden. Can't we change that a little bit? I don't know. And I would like to finish with, please, can we cooperate, help each other, give more information between the authorities, between notaries, use these possibilities, because it will help. We must learn to be a little bit more easy and not say, oh, it's against law. Yeah, I know, but we have to find solutions. Okay. And in case of any questions, you can send me an email. That's it. Thank you.
Dėkojame labai Sabine.
Thank you, Sabine. And to conclude our seminar and for final remarks, Patrick Votlet, the floor is yours.
Thank you very much. Ladies and gentlemen, we've listened to many insightful presentations on the application of that regulation. And I must say, we had excellent food for lunch, but we also had excellent food for thought. And I think we can be very thankful to all the presenters. Reflecting upon today's seminar, I think the format was also very nice because we had both a large picture and a detailed picture. The large picture was the presentation of the first presentation of the MAPE results, where we took, let's say, European perspective. But it was very nice that that the organizers also added a country-by-country presentation, because certainly the regulation is not something completely European. It's applied in the local national context. And we need to take into account the specificities of each country. So these two perspectives nicely complemented each other. So we've learned a lot. And I wanted to focus with you on 2 points. The first point is a very obvious one. We're in October 2022. We can say certainly that the regulation is alive and kicking. We had many evidence of this. One piece of evidence, it's extremely anecdotal, but is that I realized, mainly during the coffee breaks and the lunch breaks and so on, that many of you know each other, and you swapped anecdotes about previous conferences, trainings, workshops where you dealt with the succession. So the succession is alive. Okay, you're not representative for the whole European notarial community, but I think you're a good sample. Maybe a more scientific evidence that the regulation is alive and kicking is that we have already, if I'm not wrong, 12 decisions by the European Court of Justice based on preliminary reference by national courts. And I think it was not obvious, because you know how it works. The Court of Justice in Luxembourg cannot simply take up a case. It has to wait until a national court sends it. And the national court will balance two things. Okay, I have a case on succession, I have to decide, and it may be unclear, but if I send it to Luxembourg, it means the case is delayed by 12, 16, 18 months. It's not obvious that cases are sent to the Court of Justice, and it's striking that we had, in a short amount of time, quite a number of preliminary references coming from a limited number of countries. We have to underline that, you know. If you count Germany, Austria, Poland, and Lithuania are the primary sources for preliminary reference. There is one coming from France, but where are the other member states? I think they should wake up. I also find it very positive that many of the questions came from Supreme Courts. Which meant that the question had time to mature, to ripe, and the Supreme Court decided it was time to ask a question to the ECJ. Now, we've learned many things from these decisions, the rulings by the ECJ. Sometimes it's a little bit upsetting what we've learned. What the Court of Justice in Luxembourg has told us is maybe upsetting. I think reference was made this morning to the Oberle decision, June 2018. Remember, the court said that the rules of jurisdiction of the regulation, they also apply when a national authority issues a national certificate. There was a French citizen, remember, he lived in France, he passed away in France, and one of his sons asked a German court to have a German certificate, but the German court said, I don't know if I can do that. Do I have jurisdiction? No. Do I have to apply the rules of jurisdiction? Yes, said the Court of Justice. So it limits what notaries can do. And I've been told that this was not a very happy day when the Oberle decision was issued. Reference has also been made to the Kubica case. Certainly, it's a big challenge because what seemed to be outside the regulation, rights in rem, well, no, it's not completely outside. The regulation has a direct impact on rights in rem. I think, Eve, you mentioned paragraph 49. The court said, we don't care. These are simply methods of transfer of ownership of an asset. So they fall under the regulation. You have to accept direct rights or indirect rights. It doesn't make any difference. So it really changes the way national provisions have to be applied and national traditions have to be changed. Now, many decisions by the Court of Justice, but what is striking is we're still waiting for the big one, the Court of Justice deciding on habitual residence. Will it give us guidance on this major provision, the concept of habitual residence? I'm sure it will come. We'll see what the Court of Justice says. Maybe we'll develop a specific definition for this regulation. Maybe we'll say it's similar to what other regulations say, but it will take a couple of years, I think, before the Court of Justice gives us full guidance with the experience from other regulations. Teaches us that the court is really keen to provide an answer to one case and not give overall general guidance. So we'll need not one, maybe not two, but maybe three decisions from the Court of Justice. You've also heard that everybody's anxiously waiting for the case which the court will decide on land registration issue. We know the opinion of the Advocate General. I'm also glad that, and that has been mentioned, we also have seen a lot of activity on the national level. There are cases decided by Supreme Courts in Lithuania, in Austria, in France. We have 2 cases decided by the Cour de Cassation. So taking this all together, I think the big challenge is that we changed. When the regulation came out, you printed the regulation, you read it, and you had it. That's it. Now you have the regulation, all the commentaries, 12 decisions by the Court of Justice. I don't know how many decisions by national courts where the regulation used to be the Bible. Now there's a Bible and an annex from the Court of Justice and an annex from national courts. So the question here is, who's going to put this all together so that you, practitioners, can have one guide, one place where the information is available? That's maybe a task for academics to do this in a convenient way. But even if we succeed in producing the encyclopedia of the succession regulation, it will not offer an answer to all your questions because there is a dark side to the regulation. And this is obvious if you've listened carefully today. Many questions have been put forward. Most presenters have actually put forward questions. It's a little bit frustrating to hear speakers after speakers that there is this issue which is unsolved, that issue which is difficult. But I think it's unavoidable. That's part of the exercise. First, we need to understand our mutual difficulties before we can think about possible answers. So these difficulties, which we've heard today, again, especially for notaries, it's very frustrating because your job is provide legal certainty. You want a solution which is solid, robust in your member state and in other member state. And we've heard it's not always possible. And I will not, certainly not in this limited amount of time I have, provide a final answer to all these questions. But thinking about it, 2 things struck me. First, many speakers have actually insisted on the same problems. And we've heard about access to land registers, for example. It came back from this morning until this afternoon. That's a good sign, because it means that there may be, in some member states, very local issues, which is specific, but the main issues, they're not specific to 1 or 2 member states. They concern many member states. So we can think about them together. And we should think about them very swiftly, giving them priority. These transversal European questions which are still open. The second thing that struck me was that we've had discussions on many issues, but they're not always identical. You could actually sort them by categories. We have problems which are, I would say, are beyond the regulation. They're not specific to the regulation. When you apply foreign law, it's difficult. Yes, sometimes you will have to apply foreign law, and we know it's not easy. It's never easy. It's never easy, not even if you're a Belgian practitioner and you want to apply French law. Belgian law is the daughter of French law. But anytime I dive into French law, I'm struck by the differences. So, and that's, two neighbors. What does it take if I have to apply Greek law, or a Lithuanian notary has to apply Belgian law? So, but that's a problem beyond the regulation. We've also heard about the status of non-citizens in Latvia. That's an old problem. And now it comes back to haunt these people because they cannot use the possibility to choose the law. It's not a tragedy maybe, but it's a problem. I would submit, okay, let's not forget about these problems, but we will not solve them by revising the regulation. The source of the difficulty is outside, so the solution should also be found outside. The second category of difficulties are difficulties not so much with the text, the actual provisions, Article 69, paragraph 3, or Article 31, but difficulties linked to practice, traditions, cultural differences. Succession is one of the oldest fields of law. Roman law, there was a Roman law on succession, there's probably Egyptian law on succession, though I don't know anything about that, which means that we all have our traditions, and the regulation came on top of it, or next to it, I don't know, but it only works if the traditions are compatible. And that's not always the case. We've heard about the possibility to renounce your share in a future succession, something which in some member states has become a practice over the last 20 or 30 years. But it's still very difficult to accept for other member states. So there's a divide in Europe between member states where you can indeed, you may renounce your share in a future succession, and other member states where it's not allowed. The regulation tries to build a bridge between these two cultures, but it's difficult. The ECS is also a very good example. It's a European instrument, it has European authority, but it does remain dependent on national practices. And so you have some tensions here, which is certainly visible. We've heard about foreign banks not accepting requests from Austrian notaries because the Austrian notary has been appointed ex officio. There's no actual court decision appointing Mr. or Mrs. Austrian notary. So foreign banks do not trust the Austrian notary, and they require additional documents, which is a very puzzling question for the Austrian notary, because for him or her, it's natural. He or she is the court commissioner. These problems may have existed before the regulation. I think they're not entirely novel, but the regulation is, I see the regulation as a sort of magnifying glass, you know. It enlarges the problem, it makes them more visible, it puts the finger on these difficulties, which maybe have existed, but we didn't see them. What's the solution? If for these problems whose roots are not in the text, but in our practice, cultural traditions, or the fact that succession law is different, I'm maybe very naive, but I think that before starting to think about new rules, a new annex to the regulation, we should work on more mutual trust and understanding, because discussing and talking to each other, understanding each other's difficulties, at least we will have a better grasp and a more precise view of why is it problematic for you? Why do you need this document? I'd never worked that. Or why do you not accept my document? I've always worked with this document. I think seminars like this are a very good opportunity to understand each other's problem, talking to colleagues. And since yesterday, it's interesting that I had many side discussions with many of you on problems and difficulties, and many times the discussions I had on problems reminded me of things I read in commentaries, mainly German commentaries on the regulation, because they cover everything. And sometimes when reading this, I didn't realize what the problem was. But when listening to you, finally I saw the light. Oh, this is the problem, now that you explained it to me. So what do we need here? More seminars, more collaboration, more exchanges. Why not a European notarial speed dating on the European Certificate of Succession? Or anything like that. It's certainly naive, but I think it works. Now, talking to each other will go a long way, but it will not be enough. You will not solve all the problems, because some of the problems are deeper. They go to the roots. They're in national law. I'm an academic, so I speak just on my own behalf. I do not represent anybody, not even CNUE. I think some of the problems are linked to what some national legislators did. Sabine referred to Article 913 of the French Civil Code. It's problematic from a regulation perspective. And Stefan told us this morning about the a provision in the Grundbuchsordnung in Germany, paragraph 35, which says you need to have an Erbschein or an ECS. So the national certificate does not count. That's problematic. The solution here is member states should take responsibility, revise their laws, and realize if I'm the Belgian legislator, when I adopt a new law on succession, I need to think about the succession regulation. It's part of member state law. Now, talking to each other may be a solution. Talking to national legislators, we need to do this as well. But we have to face it. Some of the difficulties are specific to the regulation. Some of the problem lies with the actual provisions. Sometimes it's a minor problem. The copy of an ECS, the validity is limited to 6 months. It's arbitrary. Why 6? Why not 9? Why not 3 months? It was a decision, political decision. There are advantages to limiting it to 6 months, so that it cannot be used 15 years after having been issued, where things could have changed. But these advantages are not so great that they justify imposing a strict limitation to 6 months. It doesn't take rocket science to extend a little bit the deadline. Sometimes problems seem to be minor, but they may be more complex. We've heard the forms are too heavy, the forms are too complex, so let's simplify them. Okay, but it's easier said than done, because when you listen closely, first you realize, yes, the forms are too complex, but yet they miss some information. So we should add information in the form. And then what information should we delete? Maybe some of the information is unnecessary. This afternoon we've heard that in form number 4, the form the applicant must use to request an ECS, there's a whole section on the applicant. Who's the applicant and so on and so forth. Is that necessary or not? At first I said, okay, maybe it's not necessary, but at the same time, Article 63 limits the possibility to obtain a certificate to certain categories of persons. So we need to take that into account as well. And it's not simply an exercise of striking out the whole pages of the forms. This will need thorough discussion. Finally, there are bigger issues. Access to land registers. That's been singled out. It's a major issue. And the problem is in the regulation. The regulation creates the ECS, gives it pan-European authority, but at the same time, Article 1, second paragraph, letter K and L exclude rights in rem and registration issues. So we knew there was going to be a tension. And there we need action coming from the EU. And we'll have a decision from the ECJ. And I'm not sure the court will say, Germany shut up, or Lithuania shut up. But we'll have a decision. And yes, there is a high probability that the court will take a very European vision. It has done so until now. If you look at the cases decided by the Court of Justice, it's a very European reading of the regulation. The court said, no, member states, this is European law. We don't care about your national difficulties. But whatever the decision, it will not be the final word, because what's the problem today? The problem is that the issuing countries in which notaries or courts or whatever issue ECS, they have to adapt to the requirements of the receiving countries. If the Advocate General is followed, the receiving countries will have to adapt to ECS issued in other member states. So one way or the other will have to continue to adapt. Who will have to adapt? Maybe the receiving states, whereas now the issuing states have to adapt. You cannot escape it from it, and that's my final word. Some of the solutions will come from Brussels, certainly, revision of the regulation. And in this respect, I think the MAPE project is a very important stepping stone. We may not, in the MAPE project, in the final analysis, we will make suggestions and improvement, and maybe we will also draft some text on possible new provisions. But I think what's most important of the MAPE project is we will flag out, these are the issues you need to work on, Commission. You cannot simply reopen the regulation and not discuss these issues. Practitioners need you to decide on this. But Brussels will not solve all the problems. Practitioners also need to take part of the responsibility and cooperate in finding practical solutions for the problems you're facing. So there's work to be done, but I think it's positive because it means that we will see each other again. Thank you for your attention.
Ačiū profesoriui už puikų šią.
Thank you, Professor, for this excellent conclusion to our seminar and for the conclusion of today's work. We hope that every seminar found every participant found the seminar very useful. We thank everyone for participation, for MAPE project researchers and heads. Special thanks. Also, all CNUE representatives are thankful. We are thankful to our interpreters, for the interpreter team, which ensures also interpretation, and we are thankful to the technical team, which ensured online dissemination of the seminar. And I hope to see you in Vilnius once again in future. Thank you. Have a nice day.